The outside mentioning.
It is online, my lord.
May I, my lords, may I, my lords, kind leave to mention a matter which is listed in today's list, my lord.
ওটা চলছে
ওখানে চলছে না এটা
May I have my lords kind leave to mention a matter which is in today's list, please, my lords.
Yes.
My lords, item 10 and 11, my lord. This is that appeal from determination of mean profit.
Commercial or non-commercial?
Non-commercial, please, my lord. Non-commercial.
Bengal Shriram.
Rajshri versus
Rajshri.
Thompson.
9. Huh? 10. 10 and 11. Rajshri.
10 and 11.
Yes.
My lords, I was praying for an accommodation today, my lord. I was to start my arguments. I am on behalf of the plaintiff decree holder. I'm a bit held up before the circuit bench at Jalpaiguri, my lord. I'm not in Calcutta. My lords could kindly accommodate me.
Lordship,
Oh, I see.
I appeared on behalf of the judgment debtor, Your Lordship. Mr. Sabyasachi Chaudhary was leading me in this.
Correct.
matter.
When do you want it?
My lord, if it could be on Monday, please, my lord.
Monday.
The objection that they are proceeding with the execution, though the money is secured. Very well, Lordship. If my learned friend assures, very well.
Execution has been posted for the 1st of July.
Very well, Lordship. If my learned friend assures.
Yes.
I'm so grateful.
to mention a commercial division matter, my lord.
Yes.
It's my lord, there's an urgent application, my lord, which I have affirmed, my lord. I will file it today, my lord. But may it appear in the list, or matters appearing in the list, my lord. My other side, Mr.
Yes. Give the number, it will appear.
I'm deeply obliged. I mean, number.
An appellate side matter.
Original side, any more further mentioning?
This matter coming up tomorrow, my lord. I was seeking an adjournment for 2 weeks. I'm for the appellant, my lord. I can
Let it come up tomorrow.
I'm mentioning this matter by taking leave of the Justice Chattopadhyay, my lord. This is a contempt matter on the bench comprising, my lord, Justice Banerjee and my lord, Justice Supratim Bhattacharya. It was returnable on 17th March.
Appellate side কি আছে?
No, it is original side.
Original side. নিয়ে নাও কৌশিক দেখে নাও।
Original side. And
দেখে নাও।
one is on appellate side, my lord.
Give.
It will be appeared for the first time. This.
Which bench?
Same bench.
Same bench.
Same bench.
দেখো ওটা।
Grateful.
May I, my lord, kindly leave to mention one matter for inclusion in the list, my lords.
New contempt application.
Which bench?
Regular bench. But that was passed by your lordship along with the Justice M.D. Murli Dhara. Now it will appear before.
Yes.
May I have my lord's kind leave to mention a matter? My lord, this is lordship's order passed with my lord Justice Om Narayan Rai, wherein my lordship was pleased to discharge Mr. Deepak Deb as the receiver.
Yes.
My lord, and Mr. Shonendu Ghosh was appointed as the incumbent receiver.
Mr.
Shonendu Ghosh, Lord,
Yes.
senior advocate. My lord, he has expressed some difficulties in taking up that role.
এই পরশুদিন বেঞ্চ আছে রাই সাহেবের সঙ্গে দিয়ে দাও টু বি মেনশন।
Grateful, Lord.
May I have your lordship's leave to mention an appellate side matter, my lord. It is listed appellate side commercial item number 1, my lord. My lord recalls this is a matter where we are challenging an order refusing ad interim order on invocation of bank guarantee, my lord. If my lord may take it up today any time, my lord, subject to the convenience of the bench.
It's number 1.
Number 1 in the appellate side, my
If
lord.
you allow us to proceed, maybe we will.
Original side non-commercial. New application item number 1 to 5.
Yes. That Jaipur or Jodhpur property.
Yes.
Heard by the
Perhaps one of the other, one of Mr. Provisional Mr. Mulad was making submission. I remember also making submission Monday. Mulad, if possible.
Yes. Tell me when. Oh, I see. Yes. Yes. এই একটা নম্বর এটা করে দাও যে do not marked hard-in part, hard-in partটা within single inverted comma, এই একসঙ্গে হচ্ছিল অর্ডার একসাথে comma, these matters were substantially heard before another division bench on several dates.
Several days, Mulad also records, Mulad heard at length, Mulad on the order 16th April 2020.
On several dates, stop, paragraph, accordingly, comma, let these matters stand released আচ্ছা ওই another division means ব্র্যাকেটে নাম দিয়ে দেবে, হ্যাঁ, রাই সাহেব, আমার রাই সাহেব। Paragraph accordingly read these matters stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction.
আরে ওখানে তো you have to write to them.
Item number 6.
My lord, I was just, my lord, concluding my submission. So, my lord, I'm sorry, my lord, I wasn't there yesterday, my lord. I got stuck, my lord, before another division bench. And I have my very able junior, Mr. Choudhury, also with me today, my lord. So perhaps, my lord, it will.
He fairly confessed yesterday. He's an absentee junior.
Yes. Perhaps, my lord, it
Or
will
what
now
was the word you used? Not absentee, something else. But
increase the quality of my arguments also, my lord, now. My lord, one important, my lord, aspect of the matter, my lord, which we will, my lord, addressing is on the question, my lord, the natural justice point so far as, my lord, the suspension is concerned. So the Masonic Lodge case, my lord, which is the Victoria Lodge, that says bad faith Masonic, bad faith natural justice are both elements when this kind of incidents happen, my lord, in, my lord, a club. Now, my lord, one thing very important, and, my lord, we were considering it. My lord, earlier clubs had, my lord, very few members also, where it was more personal and where everyone knew everyone. But now, my lord, it is not so. There are several members, and now if a group of members really decided, the committee really decides now to go after someone for some reason, which is really actuated by bad faith, then, my lord, the courts would have to intervene to see at least, my lord, the procedure is followed. It's no longer, my lord, the social clubs which we, my lord, at least not us, my lord, or, my lord, our previous generation knew, my lord, which existed before. Because now, my lord, it's more of a facilities, amenities, prestige, reputation, status. So, my lord, if someone is suspended from a club, and particularly, my lord, in this case, my lord, this plaintiff was also, my lord, a past president who's supposed to have, my lord, a special status, my lord, under the articles as well. Then, my lord, the courts will have to at least, my lord, look into as to how this has been brought about. Now, my lord, just one judgment, my lord, though this is, my lord, in the context of, my lord, recalls in the willful defaulter and, my lord, that fraudulent, my lord, the Reserve Bank of India circulars, my lord, State Bank of India, Rajesh Agarwal. But, my lord, certain paragraphs, my lord, I find, my lord, extremely useful so far as, my lord, discussing, my lord, aspects of natural justice is concerned. Because the learned single judge has held that natural justice has no role to play.
in this case,
In this case. Well, this is reported, 2023-6 Supreme Court cases, page 1. And this, my lord, takes note of, my lord, the blacklisting or debarment. Now, this is something very similar in that sense. Blacklisting may be commercial, and, my lord, I had shown that clause, my lord, also in the articles, which gives me the right, my lord, also to have a interest in the property itself. That was Article 60. Well, kindly come to paragraph 40. Page 29. আমার পিসিসেন এবার আমি বেরোচ্ছি পিসিসেন হঠাৎ দাঁড়িয়ে চাঁদু ঠিক এরকম দাঁড়িয়ে চাঁদু উঠে পড়ো না process of forming, I'm sorry, Malak, page 29. Process of forming an informed opinion under the master direction on fraud is administrative in nature. This has also been acceded to by RBI and Lenders Bank in the written rule. It is now a settled principle of law that the rule of odi alteram partem applies to administrative actions apart from judicial and quasi-judicial functions. It is also a settled position in administrative law that mandatory to provide for an opportunity of being heard when an administrative action results in civil consequences to a person and entity. In 41, State of Orissa versus Binapani Day, a two-judge bench of this court held that every authority which has the power to take punitive or damaging action, so here it's a punitive action, has a duty to give a reasonable opportunity to be heard. This court further held that an administrative action which involves civil consequences must be made consistent with the rules of natural justice. The rule that a party to whose prejudice and order is intended to be passed is entitled to a hearing applies alike to judicial tribunals, bodies, or persons invested with authority to adjudicate upon matters involving civil consequences. It is one of the fundamental rules of a constitutional setup that every citizen protected against exercise of arbitrary authority by the state or its officers. Duty to act judicially would therefore arise from the very nature of the function intended to be performed. It need not be shown to be superadded. If there is power to decide and determine to the prejudice of a person, duty to act judicially is implicit in the exercise of such power. If the essentials of justice be ignored and an order to the prejudice of a person is made, the order is a nullity. This is a basic concept of the rule of law, and importance thereof transcends the significance of a decision in any particular case. Then, my Lord, Maneka Gandhi is then 43, paragraph 43. In the view of the settled position law, next question arises before us is scope and definite phrase, civil consequences. Then, my Lord, 44. Mohinder Singh Gill Malad is considered. Constitution bench of this court held that civil consequences cover infraction of not merely property or personal rights, but of civil liberties, material deprivation, non-pecuniary damages. In that case, court held that denial of a democratic right to cast a vote inflicts civil consequences. In D.K. Yadav, a three-judge bench of this court observed that everything that affects a citizen in his civil life inflicts a civil consequences. Then 45, in Canara Bank, V.K. Avasti, a two-judge bench of this court succinctly summarized the history, scope, and application principles of natural justice to administrative actions involving civil consequences in the following terms. Then, my Lord, kindly come to 46. There is a consistent pattern of judicial thought that civil consequences entail infractions not merely of property or personal right, but also of civil liberties, material deprivation, non-pecuniary damages. Every order of proceeding which involves civil consequences adversely affects a citizen should be in accordance with principles of natural justice. Then, my Lord, kindly come to paragraph 77. No, my Lord, sorry. Kindly come to 80, paragraph 80. 80. Sorry, my Lord, 79, Swadeshi Cotton, and 80. In Swadeshi Cotton Mills, this court held, page 41, I'm so sorry, my Lord, page 41. In Swadeshi Cotton Mills, this court held that a company is entitled to an opportunity to explain the evidence collected against it and represent why the proposed action should not be taken. Why the proposed action should not be taken. This is, my Lord, important. Then, my Lord, 80. I'm not reading the quotation. Odi alteram partem has several facets, including the service of a notice to any person against whom a prejudicial order may be passed and providing an opportunity to explain the evidence collected. Tulsiram Patel, this court explained the wide amplitude of odi alteram partem. Then, my Lord, if one looks at the quotation, the rule of natural justice with which we are concerned in these appeals and writ petition, namely odi alteram partem rule, in its fullest amplitude means that a person against whom an order to his prejudice may be passed should be informed of the allegation and charges against him, be given an opportunity of submitting an explanation thereto, have the right to know the evidence, both oral or documentary, by which the matter is proposed to be decided against him, and to inspect the documents which are relied upon for the purpose of being used against him, to have the witnesses who are to give evidence against him examined in his presence, and have the right to cross-examine them, and to lead his own evidence, both oral documentary, in his defense. Process of a fair hearing need not, however, conform to the...
Tell us one thing, which committee or which body in the club has the power to suspend? Is the General Committee.
It's the General Committee.
General Committee never heard the plaintiff.
Well, Lord, it had
Special committee was constituted.
No, well, Lord, they heard. Well, Lord, it was a membership committee, which was, well, Lord, on the 9th of November. Well, Lord, 8th of November. Well, Lord, recalls where that transcript is given.
Yes.
Where, well, Lord, only video recording. No. They did not, well, Lord, frame any questions. But my lord, when it came out in the letters, it seems, my lord, they said they have framed questions. Then, my lord, the executive committee gave us a hearing on the 27th of January. Where again, my lord, we don't have the minutes, but I wrote back a letter on the 30th saying that nothing was discussed. And we wanted to have the minutes on the basis of which the executive committee took such decision to issue, because they never issued a show cause notice to me. That letter which, my lord, they gave saying that, oh, you have circulated this WhatsApp, this is against interest of the club. And you justify the WhatsApp.
The minutes of that meeting still
It's not on
haven't
record.
seen the light of the day.
We haven't, my lord.
You haven't got it.
We have not seen it.
Very well.
We have not seen it. And then, my lord, what they say, and that is, my lord, also will be their stand, they say, no, look, this is nothing, because after the suspension, there is a board. That is, my lord, what my lord was pleased to stay, because they said it will lapse by reason of time. There's a board where everyone will be there, including past presidents, and they will take a decision as to whether you'll be expelled or not. But I'm on the question, my lord, first you have to cross the first gate so as to get me into that position where I will come under Article 22 to be suspended. Because I am saying suspension itself is a civil consequence and will require that you let me know what I'm answering.
But today, nothing will stop them from issuing a show cause, following due process, and going through the entire process once again.
Yes. If, my lord, that's what they, my lord,
Right. I mean,
correct. Because I, my lord, today,
why
my lord,
don't you do that?
Well, that's exactly what has happened. If your lordship, I'll show your lordship.
Prima facie, I'll tell you, Mr. Mukherjee,
My lord.
we have heard Mr. Banerjee for some time.
Yes, my lord.
We are not expressing any final opinion. Prima facie, there seems to be some personal element of malice here and breach of natural justice. So it will be much better for you. We are not there to advise you. If you just follow the proper procedure, we can't stop you from taking action against a member in accordance with the rules. We have just indicated this. You discuss this, sir.
But we will show us 6 opportunities were given. I will show all that.
All right.
But I'll
Yes,
convey it to my
yes,
seniors.
yes.
so today, my lord, the fact of, and that is, my lord, what has been, my lord, at least, my lord, the argument there, saying that, sorry, no breach of principle, natural justice doesn't come in because it's only a suspension, and you will really have your opportunity to come before the presidents and, my lord, so to say, the past presidents, my lord, where, my lord, there's a super board. So, my lord, just, my lord, to finish off, my lord, this. So, 80, I've shown, my lord, that paragraph. Then kindly look at just, my lord, this last two. 81. Audio alterum partem therefore entails that an entity against whom evidence is collected must, to provide an opportunity to explain the evidence against it, be informed of the proposed action, and be allowed to represent why the proposed action should not be taken. Hence, the mere participation of the borrower during the course of the preparation of forensic audit, this was with regard to the forensic audit, would not fulfill the requirement of national asset decision classification. Not, my lord, that is not relevant here. Then, my lord, 92. My lord, I don't think. No, my lord, I think, my lord, those are, my lord, the paragraphs. No, the judgment is issued. So, my lord, I just to show, my lord, that since principles of natural justice are brought in this kind of situation, you cannot ignore that. And these are the facets of natural justice, which also includes one should know why what is being charged with and what is that you want to do with me.
The Bombay decision also says so? No.
Bombay decision also says, my lord, following the, quite naturally, my lord, has to, my lord, look at, my lord, the Honorable Supreme. And Bombay, in fact, my lord, that is very important. I'm so grateful. My lord, the Bombay decision also talks about prima facie case, balance of convenience. Because here, I filed a suit challenging that.
Bombay case was also at the ad interim stage.
Yes.
Ad interim stage.
Yes, my lord.
Did you cite it before the learned single judge here?
Yes, my lord, we cited. Yes, my lord, it was also, my lord, at the ad interim stage. Ad interim. Now, my lord, kindly look at, my lord, the impugned order. March 20th. Well, from the memo, my lord, is memorandum of appeal, my lord, is looking at it. First paragraph, my lord, I've also been a member, my lord, from 1988, which also is a factor with regard to, my lord, the balance of convenience. '88, my lord, and I was 9 years in the committee, and one, my lord, of course, my lord, 1 year I was also the president. Then, my lord, all these facts are recorded, which, my lord, I have submitted right up to, kindly come to page 10. Paragraph 22. This is, my lord, Mr. Mitra's submission. And just since, my lord, asked me a question, my lord, on, I'm sorry, my lord, page 7, paragraph 14, my lord, I cited, my lord, the judgment of, my lord, Bombay High Court. I'm sorry, just a little, paragraph 14, page 7. Then paragraph 22 is Mr. Mitra's submission. Then, my lord, paragraph 30 onwards, page 13. Dispute arose with the plaintiff and the club when the plaintiff has circulated a WhatsApp message to all the members of the club questioning the following. Then, my lord, that WhatsApp is set out. Then 31, Rule 16 of the bylaws provides that how the complaint and suggestion are made. Rule 16. Rule 16, my lord, is with regard to, my lord, when, my lord, the food is bad, or, my lord, there's something, my lord, is not clean. That's the complaint book. I can't make this complaint, my lord, the contents of that complaint, my lord, in the complaint book. And this is, my lord, the bylaws, my lord, which provides the plaintiff is the life member of defendant of one club, also the ex-president, in spite of having the knowledge how the complaint and suggestion is to be submitted. The plaintiff had circulated the above alleged irregularities.
This is submission or Lordship's finding?
Lordship's, my lord, view.
Finding.
Yes, my lord, that's what Lordship says, because this is not paragraph 30, my lord, from page 13. Thus this court is of the view. He says, I am in breach. Lordship says, I am in breach. And you see, my lord, page 14, WhatsApp to all the members. Thus this court is of the view. Page 14, if the plaintiff would have any grievance or complaint against the club or its members, plaintiff ought to have made the complaint suggestion in terms of Rule 16 of the rules and bylaws of the club. Then, my lord, 32, paragraph, page 15. My letters are quoted, my lord, 20th September. And in fact, my lord, this kind of, my lord, I'm with a great respect, my lord, if I'm not protected by court, then be absolutely never any comment against the committee which is there. No one can raise any voice. No one can question. The whole purpose of a general meeting is for members to come about and for some members to question, so that the committee can answer, or people who are responsible or in control can answer. And that's exactly what was done. And I, my lord, then, my lord, gone after to ensure that no one will ever question the committee. This is against the interest of the club, actually. These explanations are needed. If someone has a grievance, you raise it, club answers it, the committee who's in charge. Now, no one ever will even want to question, because then the next committee will say, oh, you have questioned me, I'm now going to suspend you, because the committee is in my power. Then, my lord, page 16. This is all the narration, my lord, in the meeting held on 20th September, agenda number 5. Then I'll show the finding, my lord. Paragraph 33. He says the WhatsApp circulation made by the plaintiff was neither placed in the meeting nor had the plaintiff pointed out about the WhatsApp circulation. Clear that the issue raised by the plaintiff through WhatsApp message was not discussed in the annual general meeting. This is also, my lord, sorry, with great respect, my lord, not correct. I've shown the minutes which they have produced, which, my lord, took up all the issues. There were 3 persons who went and asked questions in the committee. Then 34, after annual general meeting, a query was made to the plaintiff to confirm whether the WhatsApp message was sent by the plaintiff or not. Plaintiff sent detailed reply on 19th October. Received a said reply. WhatsApp circular and replies answers were placed before the committee on 23rd October. And after discussion, committee held the matters to place before members relationship committee, comprising 1 chairman, 5 members. Members relationship committee held meetings answer. Request to before the members relation. Then this goes on. The narration goes on. Then kindly come to paragraph 37, page 20. In the members 37, my lord, in the members relationship committee meeting dated 8 November 2024, plaintiff has admitted that he had sent the WhatsApp message by his mobile and also admitted he had written the said letter. Question was also put to the plaintiff. Committee will give the letter minutes and everything. What would be the next step of plaintiff? In answer to the said question, plaintiff has replied, no, you give me questions so that I can give you an answer. As per the contention of the plaintiff, Rule 51 of the club provides minutes of the resolution passed at each meeting of the committee shall be fairly copied in a book and signed by Secretary Chairman. The minutes of the annual general meeting shall be open to inspection by all members for 1 month from the date of such meeting. It is the contention plaintiff. No minutes to the meeting date answered was served. After the meeting, 8 November, plaintiff had sent an email to the secretary request to provide entire unedited video recorded meeting. When said letter, plaintiff has not requested for any minutes of meeting date 8 November 2024. But this perhaps, my lord, is not, because we were going on, my lord, with regard to asking, my lord, for the minutes. Plaintiff has raised the issue that no minutes of meeting date was served, recorded only after receipt of queries. This court finds with the concerned plaintiff meeting and videograph unedited copy. Specific case of defendant, the secretary could not be present. Answer, this one goes on. Then the court said that this court is of the view, the last 3 lines, that the unedited copy of the same was served to the plaintiff and the videography was conducted by consent of plaintiff. Now the plaintiff cannot take the plea that no minutes of the meeting was served upon the plaintiff. Well, videography does not mean I've given consent, my lord, that no minutes will be given. Minutes are required for every meeting. Then in one hand, now, my lord, kindly see, in one hand, the plaintiff is relying upon Rule 51, the club rules, which reads as follows. This is, my lord, minutes of meetings. Then, my lord, kindly see page 22. On the other hand, plaintiff has circulated WhatsApp message making complaints not following the procedure provided under Rule 16. That can't be, my lord, a reason to. Then, my lord, goes into
Rule 16 contemplates something else.
bylaws. Yes.
Bylaw 16.
Yes.
Any complaint that to be filed with
That is, well, every club has that. Any suggestion for improvement or any deficiency in service, quality of food, is that kind of a complaint.
my lord, we'll place, my lord, your lot
Anyway.
will consider after
Yes.
we'll place it, my lord.
Yes.
So, my lord, kindly see, on the other hand, plaintiff was circulated. Then, in the case of R.N. Goshen, this was not, I don't think this was cited by anyone. Anyway, Supreme Court held that law does not permit a person to both approve and reprove it. The principle is based on the doctrine of election, which postulates that no party can accept and reject the same instrument. My lord, I am with great respect, my lord. I don't know how, my lord, this is at all relevant. This is not the case we argued. Then it is 39. It is also the case of the plaintiff that before issuance of the order of suspension, no show cause notice is served upon the plaintiff. Then, my lord, Rule 22, my lord, is quoted. Then the plaintiff in supporter's case relied upon the judgment case of Gorkha National Securities. My lord, our cases. Then paragraph 41, UMC. Then, my lord, 42 judgments. Then, my lord, kindly see 43, 43, page 27. This Madras case, my lord, the power of suspension not a punishment, that is quoted. Then 44, paragraph 44. In the present case, after circulation of WhatsApp message by the plaintiff, notice was issued to the plaintiff for confirmation whether the said circular was sent by the plaintiff or not. To give an opportunity to plaintiff, members relationship committee was formed. Said committee has given personal hearing to the plaintiff. After the said meetings, 3 queries were made to the plaintiff, but the plaintiff has not answered to the said queries in spite of several opportunities. Executive committee also given opportunity to plaintiff to explain the basis of the allegation meeting on 27 January 2025. But in the said meeting, also plaintiff has not explained. And again asked for the minutes of the meeting dated 8 November. Though by an email dated 25th November, it is informed to the plaintiff, meeting dated 8 November was videographed with the concurrence of plaintiff. Video recording should be treated as minutes of the meeting. In fact, Malad, the transcript said that there will be a minutes which will be sent to the executive committee. Malad will recall that. In spite of several opportunities, plaintiff failed to answer the queries. Accordingly, the defendant issued the impugned order of suspension invoking provision rule 22B2 of the club. Then plaintiff is placed under suspension, called upon to resign from club as member rule 22B2 as per rule 22C. If the member concerned shall not do so in 24 hours, thereafter committee may refer to the special board for decision as to expulsion or otherwise of the member. Terms of Rule 22D, the plaintiff is also entitled to nominate 3 gentlemen permanent members, and one of that is quoted. And then page 29. The cases relied by the plaintiff are connected with the blacklisting, and there is no quarrel that on the proposition that it is mandatory requirement to give show cause notice before blacklisting. In the case of the plaintiff is a suspension pending inquiry by the special board, plaintiff will get an opportunity to place his grievance before the special board. Thus, there is no necessary to issue show cause upon the plaintiff before issuance of order of suspension. As regards maintenance suit, this court has not gone into adjournment relief. This court finds the plaintiff has not made on primary case of balance of convenience. The favor, adjournment principle refused. Defendants have already entered appearance. So there's really no consideration of paragraph 14 when we cite the Bombay High Court decision. And then 2 reasons the learned judge with respect goes into. One says approbate, reprobate. Rule 16 I have not followed, therefore I can't insist on rule 51.
Anything else?
And we had filed an application to show the bad faith is apparent because before when we filed it, then only before the expulsion also they've removed my name from the list, and that is also on record at page 440. So the bad faith.
You filed an application
Just to put that on record
before the learned single judge.
Just to, this is part of the bad faith which we are. It's a supplementary affidavit which we had filed.
Page
440, para 5, supplementary affidavit, sir. And we had given the list as well.
Let us hear them.
Yes, I'm so grateful. I'm taking for just 5 minutes. I'm taking sure.
Mr. Mitra will take over, Mr. Abhijit Mitra, when he comes over.
Mr. Mukherjee, normally we don't allow that. But Mr. Mitra is here.
So Abhijit Mitra.
I see.
They prefer the other Mr. most probably.
Lordship, there's another respondent, he can start and then we start.
Mr. Mitra is appearing for whom? Mr. Anindo Mitra?
For the club. The
But
respondent number 1 and 2.
I had argued with trial court
And Mr. Abhijit Mitra is appearing for whom?
with me.
With him at Aruduto president, present president. My respondent number 3 was also the president.
Who is also the president. 1 is the club.
1 is the club.
2 is?
Who is the second?
3 is the president.
He is the president.
I'm happy with the club.
And the others are the other committee members. Yes.
May it please your lordship. But the first point we have raised that this letter which was issued in the anonymous letter, as we call it, circular, that was placed before the annual general meeting, argued before them, placed before the AGM, and considered, and therefore matters should end it there. You know, this submission is factually incorrect. Factually incorrect. That AGM was never placed before the AGM. That a circular notice. And I'll take this point one by one. The anonymous letter was raised and clarified at AGM. Answer is factually incorrect, and it was not raised. Number one. Why incorrect? No such case is made in the print either. This argument is dehors the pleadings. Now, I shall show you lordship from the record, it was not placed. The minutes of the AGM is available on record. From that, it will appear this letter is never placed. So this is, now let us see why this letter written. Number of the fact, the question now raises, management rightly argues that a member has a right to say that irregularities, financial irregularities going on, etc. Member can agitate that point. Agitate according to club discipline, club rules. Now this, kindly see the notice of AGM, which was given. Please come to me, Lord. And the notice of AGM invited the members. Page. Yeah. The notice of AGM is at page 281, volume 2. Actually, it's usual for all clubs, similar intimation. Page 281, you might not got it, Miller. Kindly see the serial number, agenda number 3. To adopt and pass the accounts of the period ended 31st March 2004. This is the and see the note at the bottom. Facilitate adequate replies to members' queries. Only question received before 20th September will be entertained or replied. No other question, discussion, resolution may be taken place. So every member got an opportunity to place the grievance against the account of 31st March, right? Now, this gentleman, the plaintiff, this is the usual course by which one member should ventilate his grievance against the accounts, if any. This is the club procedure, club discipline. Now, my lord, in this, after this gentleman, my lord, he, within 20th September, raised the questions regarding regarding the accounts of the 31st March 2004. See that letter below.
Plaintiff.
Yes, he did, and that letter was suppressed. But that suppression is now a minor vice. Now let us see, Lord, what actually it amounts to. Yes. Please come to me, Lord. Page 536, volume 4. Kindly, my Lord, is the date September 20, sending my email and the letter received by the club within 20th on 20th September 1950. I am member of the club, membership number is given, full disclosures. In terms of Rule 49 of our club rules, I would like to raise the following question in the ensuing annual general meeting fixed on 8th September. So with the Rule 49, the notice allows or provides the method by which a member is to ventilate his grievance against the accounts or anything about the club. Now, let's see the questions. How much money was spent to renovate the men's changing room and bar number 1? Question. Question, whether any quotations being taken before the start of work? If yes, how many vendors? Then put them in. This letter received by the club and the show later on, it was placed at the annual general meeting. Queries were answered and there's no further grievance. Anonymous letter, anonymous letter, anonymous letter. Sorry. But here, whatever grievance he has said so. Then, after writing the letter, why issue an anonymous circulation mail letter to the members? Is it a bona fide act? Is it an act in compliance with the club rules? Now, this letter is at page 326, volume 3.
The anonymous letter.
Yes, the anonymous letter.
Page.
Page 326.
326.
326. Volume 3.
Yes, Mr. Banerjee showed us that letter.
Yes, this is the basis of it. And he made a lot of submission on this, that letter raised that made. I show submission factually incorrect. Now, my lord, if all these grievance could be mentioned by him in the personal letter, which is read on 30 September, then why these anonymous letters circulating among all the members? Similar in the club rule, the basic thing I think, Lord will correct me if I'm wrong, is a privacy. Maintenance of privacy. A member has done something wrong or something good, matter of privacy. If the committee has done so many things, you write to the committee, and then your grievance will be ventilated at the annual general meeting of the members. That is the I think, keeping with natural justice and most better form of natural justice. Keeping them in. Now let's see why this letter then, and why those things were not incorporated in a letter of 20th September 2094. Any basis, any answer? And this is without being written to all the permanent members of the club, sent by WhatsApp. 2 or 3 days before the AGM election.
So you are saying he did it to discredit or malign the committee, members of the committee.
That will be also that will be reasonable inference from the facts. I am placing the facts only now. In answer to my learned friends, malafide, etc. Malice on whose part? That's the thing. Now, it is a natural question of everybody's mind. If this gentleman member
Suppression এটা মেটেরিয়াল চিঠি মেটেরিয়াল সাপ্রেশনের জন্য we can deny equitable relief. Absolutely. Good material চিঠি. Yes.
similar this letter, which is to all members,
লজিকগুলো পুরোপুরি ভুল সেটা রুল 16 রুল 16 contemplates something else. হ্যাঁ মেম্বারের যদি মনে হয় খাবারটা কোয়ালিটি খারাপ মেম্বার যদি মনে হয় বাথরুমে এটা ফেসিলিটি দরকার সেখানে এইসব নিয়ে কমপ্লেন লেখার জন্য কমপ্লেন বুক থাকে না আমি তো 7টা ক্লাবের yes.
see, this matter, my humble submission, these letters were sent after this anonymous letter was sent after 20th September 2024. After writing this letter, it was 2-3 days before the AGM, the 26th September AGM, that this letter was circulated.
Yes, Mr. Mitra.
We are all, it is addressed to all members of the permanent members circulation and sent by WhatsApp. So these are the queries, A, B, C, D, etc. Can you see F, for example, F? Whether 3 quotations are invited before allocating work to a particular vendor. The similar question number 2 in the letter dated September 20. Second question. Similar, this other thing also could have been incorporated there. Did not. Now, another thing, more than a serious charge, 8.25 crores have been spent on building, etc. That is a matter of, according to the plaintiff, it is serious financial irregularity.
We followed, Mr. Mitra. You are saying that having written the letter dated 20th September, it was wholly unnecessary and unjustified for him to issue this anonymous message on WhatsApp.
Yes, that's right.
And that was mala fide only to malign or discredit the members of the committee 3 days before the AGM.
That is similar. I am humbly submitting a prima facie inference court should draw.
No, this is what your case is.
Yes, my case.
Yes.
That's my case. Can you see, Miller, the last but one paragraph of this letter? I urge you to mark your calendar and make every effort to attend the AGM on 20th September 26 to contribute to this important discussion and decisions. In that, see the previous paragraph. What is the purpose? During the AGM, we will try to provide a detailed overview of the financial irregularities that have been identified, discuss their potential impact on the club, and collective work towards finding solutions to rectify these issues. Your insight, etc. It is so this will be placed before the AGM and further things will be discussed. So come and join. Question is, why this letter was not placed before the AGM? And discussions were invited on this. This anonymous letter could not be placed by the secretary or member itself. The question, the letter he has sent to the secretary in terms of the club rules was placed and discussions were held on that. Now, kindly bear in mind, this letter was only issued to create some prejudice among the members that the committee members are indulging in financial irregularities.
You say that his letter dated 20th September was placed before the AGM.
Yes.
Would that be reflected from the minutes?
Yes, yes, yes.
Where are the minutes?
Yes, minutes are there. Minutes are there. Page 551. That has not been shown to court. The 551. 551. The number. Volume?
515.
Don't you got the volume?
315 এখানে থাকবে ঠিক আছে
My lord, kindly take this volume 5.
Yes.
And please kindly come to page 533. 533. Number D, middle of the page. Middle of the page. The question, Mr. Jay Surana, query, inquired that how much money was spent to renovate the men's changing room and bar number 1. He also asked whether any quotations were taken. If yes, how many? Was it not prudent? The questions are all set out. Then answer. The amount spent on the men's changing room was 1.35 crores and the amount spent on the bar number 1 was 202.73 crores, thus statutory charges. Yes, quotations were taken from multiple vendors as and when required. Mr. Rishi Bajuri also indicated that this whole renovation process was started by Mr. Surana when he was the president. Continue. Now, after this, my lord, no further question from Mr. Surana at the AGM meeting. He did not ask the question as put in that anonymous letter. What I got? 326. Why 8 crores were spent? 8 crores were not spent in 1 year. 8 crores and spent in building, furniture, and etc. Why investment come down to 2.5 crores? This question he did not raise.
Yes.
Only the quotation question, which was in a private letter, personal letter, is question.
The WhatsApp message was 23rd September.
25 September. Just 3 days before the 20th September was the AGM election, 25th September. So, my lord, what at this stage before taking evidence, what inference can be reasonably be concluded? That in my humble submission, at this prima facie stage, it can reasonably, it is reasonably to be inferred and concluded that this letter, anonymous letters, was sent not for the bona fide purpose of bringing this alleged financial irregularities at the annual general meeting for member discussion, but was for the purpose of poisoning the mind of members against the committee members before 2 days, 3 days before. And maybe there will be committee members seeking re-election. I do not know. Most probably they do.
Yes.
So, they can get to the next chapter now. Go to the next chapter. Meeting was over. AGM was concluded and everything concluded. Then the committee members wanted to know, firstly, whether this letter, undated letter, what I'm calling it anonymous letters, was sent by the plaintiff himself or not. Because this letter only contains a signature, no name or membership number. But signature in the photocopy as it's sent appeared to be that of the plaintiff. So, the committee decided to engage a members' relation committee to find out this, whether this letter was sent by him. The members' committee, my lord, that have seen this, took 3 meetings. They required 3 meetings to ascertain from him, yes, that it was sent by plaintiff. I will give the dates and details or to give you a lordship. First is a serious attitude, my lord. Simply asked, question was this letter sent by you?
Is it called the membership relationship committee or members?
Membership, you know?
Members.
No, sorry, my that may call MRC here, which is better. MRC, yes, sorry, that is everything. Members Relation Committee. Sub rules provide for that.
Yes.
Now we will see the first letter. What was written to him, and what was there to be so much angered by this. All that we show, Lordship, all that the committee member wanted to know. Please tell us what is the basis for you to make this financial irregularities allegation. Basis, just the basis. If you had a good basis, all right, bona fide. He made a misjudgment. But if was it baseless? That was the only thing asked of him. After he admitted that it was sent by him, then only question asked, please tell us what is the basis for this. Without annually letter saying making serious financial irregularity, that is their own case. The committee wants to know what is the basis for this. Anything wrong there? He was just required to say, yes, this was the basis. Then committee say, yes, that was a reasonable basis. I will stop that. But the person deliberately does not disclose the basis, deliberately avoids disclosing the basis. What is the conclusion? That he had made a baseless allegation of financial irregularities against the committee, against the management. And that baseless complaint was widely circulated among all the members. And that was done 2 days before the election. No step was taken. May I now show you the fact to justify what I'm saying. First step, to find out, have you sent this letter? Because the signature sort of appears. Let us see. Please, Minna, take volume 3. 4 or 5 days before AGM dictated. 4 or 5 days. 2-3 days I made a mistake. I'll just go by record. Kindly come to me, Lord, volume 3, page number 2, page 327.
These letters have been placed. All the letters have been placed by Mr. Banerjee.
Now, yes, instead of placing that, they give you the summary of it, that chronological order. That the letter is dated.
I'm sorry to interrupt just one point. Actually, there was no election on AGM day. It was just the AGM which was held.
Oh, no election.
No election.
I-
Because nobody
I
stood
stand
for any
correct.
election.
I stand correct. Oh, I guess already covered. Oh.
election হয়
He is right. No election because the committee was elected uncontested. So that was the date for election of committee. Am I right, Mr.? No. So I didn't make any misstatement, fortunately, because usually that happens in the club, all clubs. That was just fixed for election.
Yeah.
No contest. Hmm?
Yes.
I'm not placing this. Right? I just want to give the dates. We'll give you. Have you given a list of dates? We have given a list of dates.
Yes, better.
That will be better. Number first question. I'm telling factually not correct. That was this letter written by you? Answer was, who are you asked to ask? Why are you asking this question? He avoided giving this as a third meeting. Yes, written by me. He attended. Then what the committee wanted to know? What was the charge? What was the basis for these allegations of financial irregularity? Just this was the basis. On what basis you said so? That a member can make an allegation, grievance, with some basis. If you ask on what basis, then the committee will balance and view, should reasonably view, whether these allegations, serious allegations, had some basis or not. If you are not baseless, committee may stop. Yes, there may be misjudgment on your part. But these 3 questions were raised. Ultimately, Milord, can you say 3 questions which are raised? And the question was, which is important, Milord, this letter will come back to you at page 332 of the volume, same volume.
E30.
ও তোমরা দিও। Now, see, Milord, this letter I'll place, but can you read once more with me, Milord? 332. In furtherance to your meeting with the member relationship committee, he কি বলেছেন committee on 8th November 2024, wherein you have confirmed signing and circulating the undated letter through your WhatsApp to the members at large of our club 4 to 5 days prior to the annual general meeting, held on, etc. And as desired by you, can you see me, Lord? The MSC 6 clarification of following queries from you. As desired by you, can you make a mark for convenience, page 472. It was desired by him. Can you bring 472, page 472? And see the minute the question B, you have made mass announcement, significant financial, etc. Club. Please explain. Please explain. See that what you are asked to do. Please explain. You have made a mass announcement that there have been significant financial irregularities with the club, within the club. Please explain. Number 2, you have chosen to send an unnamed and undated letter on a plain white paper with you, with only your signature members, with your assumption, without any prior clarification or facts. Being a past president, what was the purpose of sending such unprofessional letter? Action cause, etc. Please explain please explain all things. Please explain, please explain, please explain. 3, all the 3. Further, as requested by you, paragraph 3, your video recording is being attached. Now, Millard, kindly come to page 472, which is the transcript of the video recording, which they have now produced.
Page
472. Volume কত হবে? Volume 4. Please, Millard, come to page 472, volume 4.
কোড করা আছে।
আচ্ছা, কোড করে
472.
Volume 4, 472.
Oh.
It starts at 462. 462 starts, Millard. 460 starts at kota?
452.
450 starts at.
452.
Starts at. Kindly see, come to page 460.
This is the
Point
transcript of the video recording of the 8th November meeting
8th number meeting.
before MRC.
Transcript made by him. The transcript disclosed by him in the proceedings.
Yes.
Yes. Kindly come to page 460. The third, Mr. Jai Surana. See, nobody asked me any question except whether it is my signature or not. This is a question. Now, I'm not prepared to answer what I don't know, what you will ask. So, give me a question. I will give you a written reply so that everything is in paper, pen and paper. Then, Punjabi correct. So, after you have given me the question, you give it to me, give me some time. No. Then can you come to 472? Get what I was already 472. Middle. 470, I'm told. 470. I'm sorry, 470, the second paragraph. The Jai Surana. What I'm trying to say is, if you have any question like financial irregularities, you tell me, I will answer. 472, I'll be 472 can you come? That I will answer in case of interview, etc. Moyes Punjabi, fair enough. So, okay. Tandon, we will all wait for your reply. Jai Surana, I will wait for your question. I'll wait for your question. Yes, once you get the question, you will get the reply. Jai Surana, I must get the question. And he promised that in the questions are given to him, he will give a reply. Now, the argument of a learned friend in the appeal court is that MRC cannot frame any question, cannot put any question to him. But he did not apprise your lordship that he himself, his client himself, asked the MRC to frame the question to go for his reply. So, the arguments are factually incorrect. But these things, then
Was this meeting not minuted, the proceedings of the meeting?
this minute. Kunta. Yes, this letter has been quoted in the letter asking him to show cause.
Because you see at 473, Mr. Mitro,
Yes, Milord.
Rahul Singhi says,
Rahul Singh.
the minutes
And
of
then
this
whatever
meeting
is the
shall
final
be
call,
intimate.
it will be taken at the committee. And the same shall also be intimate. Committee took up this. Committee framed the same question.
Prior to which the minutes of the meeting shall be intimated to you.
Here. Yes. You shall be intimated to you prior to the which minutes of meeting. Yes. Minutes of,
They have made a big issue out of this, that although it was stated in the meeting, as was videographed, and this is the transcript, that the minutes will be sent to the plaintiff prior to the matter being placed before the general committee.
yes.
Till date, minutes have not been made available.
The videograph minutes have been sent to him. See, Milord. Now come the question.
Yes.
Now to see, Milord. A minutes of the meeting can be taken down by stenographer. Minutes of the meeting in the modern days can be videographed.
Do your bylaws provide for that?
Bylaws does it prohibit? As it required to provide for videograph. When the bylaws are made, videography perhaps was not known. I did not know. But question is this, what the purpose of the minutes? That what happened in the meeting will be truthfully recorded. Now, is it not more satisfactory that whatever happened in the minutes are being videographed, so that no question of any human error, stenographer making a slip there or making a mistake there. So, I highly kindly see,
And
having
the
regard to
authenticity of this video has not been disputed by
not
anybody.
at all. On the other hand, he has got a transcript made of the video and he has disclosed it. I can remember.
Yes.
Secondly, my lord, Lordship has not told that the plaintiff himself asked for this video recording. This letter was, please correct me if I'm wrong, this letter is 9th November 2024. This was placed before the trial court and judgment record. This letter sent, I am handing over this letter. This letter they have included in the paper, but not this. Some mistake. Inadvertently, they have omitted this letter. But this letter is recorded in the judgment. So, may I, you may like Carnation's kind permission, point out these two letters to you.
Inadvertently.
No, I'm not. As you are, this is 12, 11. Judgment take it. Page 17. You were aware that yesterday, 8th November 6 p.m. attended a meeting convened by the members committee. At the outset, Mr. Kanan Tandon, chairman of the members committee, asked me whether a video recording of the entire meeting be done, to which proposal I readily agreed, but subject to an unedited copy of the said video recording be forwarded to me, must be forwarded to me. All the members of the members management committee, which included Mr. Kanan Tandon, Mr. Mahesh Punjabi, Rishi Vajuria, etc., agreed the same would be provided to me. Late yesterday evening, I had forwarded a WhatsApp message to Mr. Kanan Tandon, requesting him to forward the video recording positively by today, 9th November. To which request he replied that same will be sent. Under the aforesaid facts, circumstances, you are requested to kindly forward me video. Suppression is a minor vice nowadays. No, that this letter was produced for trial.
Are you sure it is not in the paper book?
540, a different letter has
Letter has been annexed, but not this.
It's also recorded in an order. In a
Then again, 540 letter is like
540.
540. So Lordship will find a letter of 9th November is only annexed.
Yes, but that's written to the plaintiff.
So that this is the letter which we had relied on this
Is
letter.
not there.
And one of this letter was actually part of our written notes.
And in the
Document that 540 had wrongly been annexed to a written notes which had been replaced. And that is recorded in the order also of 13th March 2025. And the order impute records this letter on 2-3 occasions.
This was not a part of arguments with the written notes. Below this was
No,
given.
we had argued, we had placed this. Mr. Chaudhary may have been absent at that point of time. We had placed it before the during the
Very well. Allow
We
Mr.
have no objection, Millard.
it is enjoyable.
Can't you really settle this matter?
When Mr. Surana first came to
Club
me,
matter, it's a club matter.
This opportunity, the the committee special board is comprised of special board who will consider this case for everything will consider suspension, expulsion, everything.
Millard, that is for perfection of the guillotine. Millard, when the matter first came, I requested Mr. Agarwal, don't take it to court. Please finish it off. This is not something, Millard, which should go to court.
Very good.
Anyway,
Then we have come to court thereafter. Anyway, that is a special board. And I showed the rules on the shoulder also. 19 past presidents had attended the last meeting, which we had to be adjourned because of court's order. But I'll come to that aspect later on. Now, question about why a person should allege that the videograph is not done, is not the club rules, etc., while he had himself agreed in writing, yes, it will be done, and you are sent to him. Whatever you call me, not a very bona fide stand taken by him. Now that this letter was mentioned in the judgment of the trial court, it was shown. Now let's come to the main topic of it. What is the club rules provide for suspension, expulsion, etc.? Club rules. Club rules provide for compliance with natural justice, but in a different form, and in my humble submission, a better form. Not by show cause notice, but simply giving a notice that come and appear before the committee. Committee want to hear you. Then committee will apprise him what are the charges against him, and he will take his time to reply. Take his time to reply. He has not required that reply then and there. Take it exact, that's what happens. And that will maintain the privacy of the member. If a show cause notice issued, that will be typed out by the club stenographer. Department will know. everybody, and that will be issued to him. That become a matter of public. That is, notice has been issued against the person following charges. But the better course is to have a man-to-man talk. The club rules provide for that. See the club rules now. Rule 22. Rule 22.
Second one, 175.
Page
175.
At page 175. It starts earlier.
Starts at page 150. The first
Rule number 20. Suspension, heading, suspension and expulsion.
This has been quoted by the learned judge.
In the meeting. What I want to show, what is the procedure prescribed by the rules? Is it in violation of natural justice or in compliance or better compliance with natural justice? See me down. B. If it shall be alleged that any member of the club has committed a grave breach of any rule, bylaw, or guilty of any or responsible for any conduct, act, omission, whether within or outside the club, such as to affect the character or good name of the club, or cause any annoyance to other members, or if the committee satisfies the member or any relation of member enjoying the club facilities under the responsibility of that member has given any monies, gratuities, or other inducement to any staff of the club, then committee may request such member to appear before them at such date, time, and place as may be specified. And if the member shall then fail to appear as requested, or on appearing shall fail to give explanation acceptable to the committee for the matter alleged, committee shall have the power. Full notice hearing have the power to then caution member, suspend, and not exceeding 3 months, etc. But so what is the mode of compliance with natural justice? Give a notice to that person to come before the committee. The committee will apprise him that these are the charges. What's your explanation? Give your explanation. It's not that the club rule does not provide explanation must be given then and there. As in this case, after find a lot of adjournments were taken. 6 adjournments were taken to give the explanation. Is this any law written anywhere that the national justice compliance can only be done by written notice to show cause? This is the point. Not the club rule provide a particular mode of apprising the member and asking him to show cause. That particular mode has to be applied, and that has been applied in this case. So, what is the violation of natural justice? Then we have to come to other part of Lordship will rise now.
Yes, for 4 minutes.
This is that will pay the whole of it. Rule 22.
Yes, yes.
Volume 2. Got it. It's the whole of the rules. So, my lord, it is a mode of compliance with the basic principle of natural justice is prescribed by the club rules. Namely, give a notice, give him a hearing, tell him this is the charges, you please explain. Rule does not provide that he must explain then and there. In fact, in this case, several opportunities are given to them to explain. So what is the basis for writing this? Now then what the rule then provide? Then the club rules do not provide for giving any show cause notice as such. But provide for actual giving a written notice to appear and then apprising the member of the charges against him and giving an opportunity to member to explain.
Mr. Mitro, we have followed. We have followed. Please just now, if necessary, we'll again hear you. As of now, it may not be necessary to hear you further. Just if you want to deal with the cases, Masonic Lodge.
I shall give the answer technical points raised.
Yes, yes, because
now technical points.
You understand why we say that. If necessary, we'll hear you again.
I propose this matter. I tell you, Dr. Milad, now come to the rule 22. That will give the all.
Yes, we have seen rule
that's
22.
The solution.
We have seen rule 22.
Section rule 22. We turn the page.
The special board may even revoke the suspension.
Yes, and who is the special board?
All past presidents present in Calcutta, plus.
And the 21 past presidents in Calcutta. 29. At the last minute, a meeting was called for this consideration of 18 ex-president of the club was present.
Mr. Banerjee will give reply today.
Yes, but I'm not sure after Mr. Mitra, Mr. Abhijit Mitra, I think also would like to make some.
We may not hear him.
It depends on the attitude. At that meeting, if the gentleman calls, says,
if necessary, if we feel, then we'll call upon him.
Gentleman, is for him. If you're 18 president, if he says, I apologize, I shouldn't have said his ass, I withdraw my remarks, then they might consider the thing. A person calling the committee members his ass, is he a befitting member of any civilized club? Unless he withdraws, but he has chance to withdraw. The judgment Bombay High Court they have cited, that the person withdrew his remarks.
Bombay High Court?
Bombay High Court judgment is cited now. In the judgment of 2005, with the gentleman member, he withdrew. So suit was filed, he withdrew his offending remarks. But this is the opportunity for him to settle at the meeting.
No, withdrew the remarks after filing the suit.
Which had been filed by the member. The member had started a new club using the same name as the club. There was a suit which had been filed also. That suit was withdrawn by him.
And he also said, I shall not, NSIC, I will not use.
NSIC, I will
not use. That is that will rely upon. Now, this is, but I humbly submit the rule as given by the club is not challenged by anybody. Not in the suit, that it is violative of rule of natural justice, it is void, bad, etc. Not challenged. And it's not argued either. And the rule matter, I really have sympathy for. He has simply, if I repeat, he may appear before that 18 members committee, past president, etc. He can say that, I'm sorry, I'll give the explanation. This is the basis for my saying it.
Very well. Yes, Mr. Sharkar. Anything in reply?
If your lordship,
If you are starting your reply, do not seek adjournment after that.
no,
Finish it off then today.
lordship, may kindly take page 346, volume 3.
May I take my last kind leave?
Yes, yes.
Juniors are here. They are more competent than me. That was a bit.
That can never be possible.
Never.
No, I'm winning. Just feeling that. I just
Yes, please.
But not, nothing more than that.
Page 3,
346, volume 3.
346. आगे देखा ही नहीं.
This is the email of 29 January after the email of 27, which was given to me by the executive committee.
346 we have marked. It has been placed by Mr. Banerjee.
Yes. There, what Mr. Mitro just now said, that I could have sought and gave an explanation, or I could have simply apologized. In that email of 346, I have clearly mentioned that I have never meant to make any allegations against the committee, and if required, I am willing to write it to all the members of the club. That was first my stand. Second, as per the transcript, and this email was not considered before suspending me on 30th of January. And in the transcript,
Mr. Shorkar, we shouldn't be even hearing you. You did not draw to our attention the plaintiff's letter dated 20th September 2024. Very material. Secondly, you did not draw to our attention, nor did you include in your pleadings, we are told by them, the letter dated 9th November, whereby the plaintiff recorded, yes, I agreed to your video recording the meeting. Please send me a copy, unedited copy, as we had agreed. After that, how can you urge these points of there's no minutes?
Your Lordship, I asked this. Yes, I have asked for the copy of the video recording, but I asked this question.
What about the suppression? You're very well aware. We don't even want to hear you. You are before a court of equity.
Lordship.
Yes, sorry. Make your submission. And please conclude. There are other matters to attend to.
Your Lordship, the video recording was asked by me because I was told that there is no secretary, so it will be video recording. I agreed to that. Then later on, I said, give me a copy of the video recording, but as per the transcript, which was shown on the last, at page 440, on the last page of the transcript, I'll just run your Lordship, just for two. There, I have specifically said that the question should come from the committee, not the MRC. That is one. And today I ask this question to myself. Can a video recording of a meeting supplement or substitute the minutes? If I go by that logic, then today, Lordship will not take me amiss. Then there's no question of your Lordship passing any order. The YouTube streaming is good enough. Because a lot of things are discussed, but final conclusion comes in the minutes. So that is the very purpose of the minutes which the rules provide. So there was no question of maligning the committee. The MRC had called me. The meeting was held. Then on 27th of January, no questions came from the committee. On 27th of January, the executive committee's meeting came. I had written, in the meantime, I was out of India, which I had written to them. That's why the adjournment was sought for. It was during the winter vacations, the courts, since he's a practicing advocate. Then on 29th, I wrote to them. I said, this email, I have no intention to malign the committee. The very inception of this notice immediately after the AGM was to target me so that to set an example by the committee.
That Mr. Banerjee has submitted.
Yes, Your Lordship. And if Your Lordship may kindly, just for my sake, just the transcription. Transcription 472, Your Lordship, once. volume 4, Lordship.
Kaushik. I think.
If your Lordship may kindly see
Hey,
472. I'm not 472, Mr. Mitro has shown the middle part where I said, yes, you give me the question, I'll give you the answer. If your Lordship takes the fourth entry from the bottom of the plaintiff, so I take it granted that the committee will put the question. So I was expecting the question from the committee, not the MRC. From the MRC, all I So at the end of the meeting, it was decided that the questions will be the minutes of the meeting will be placed before the committee, and the committee will put the questions to me, and the minutes will also be intimated to me. These are the two things. Neither the minutes were forwarded to me, nor the questions came from the committee. The secretary wrote to me saying these are the questions formed by the MRC. That's why the answer was never given. Because I was expecting the questions to come from the committee, executive committee. And as I said, that yes, I have accepted that you forward me a copy of I have sought for the copy of the videography, but at the same time, the minutes was also one of the conditions which I sought for, and that was agreed upon in the meeting. If your Lordship may kindly see at 473, Mr. Rahul Singhi, and then whenever is the final call, it will be taken at the committee, and the same shall also be intimated to you prior to which the minutes of this meeting shall also be intimated to you. So it was never the question that the videography will be treated as the minutes. And also the last line, second last line before at page 472, Mr. Rishi Bajoria, no, we have not placed this before the committee as yet. So committee was completely unaware what is the finding of the minutes with the MRC. So before anything comes from the committee, all I get after 8th November directly from committee is of 27 January. So there was a 2 months gap, almost more than 2.5 months gap. Straight, I get a committee's notice, why you should not be suspended. But no charges was leveled against me. I was not aware what I have done, what will be the consequences if I don't reply. And I was straight away suspended from 30th of January. And on 29th, I specifically, as I pointed out, Your Lordship also, Mr. Banerjee has shown, I have said to the committee that there's no allegation against the committee. If required, I'll write to all the members. It was only the financial discrepancies, the entries, which I wanted to highlight.
Yes, sir.
If Your Lordship may just allow Mr. Banerjee 2 minutes.
What? You want to add? Please finish by 12:30. There's a matter fixed.
Yes. I'm told, my Lord, I'm sorry, my Lord, I wasn't there, my Lord. I went to my Lord for another matter. My Lord, I was told, my Lord, that 2 issues, my Lord, at least, my Lord, that's what I understand, my Lord. One, my Lord, is a letter, my Lord, where, my Lord, 9th November 2024, which is, my Lord, saying, my Lord, we'll have an unedited copy of, my Lord, the video recording. If that's an issue, my Lord, that can't be an issue because that, my Lord, doesn't, my Lord, absolve anyone, my Lord, from having the minutes. And throughout, my Lord, we've had, my Lord, letters in writing saying that we want the minutes. Because we agreed, my Lord, to video recording will not, my Lord, be a substitute, my Lord, so far as minutes are concerned. My Lord, that's one thing, my Lord, which is very important. Because, my Lord, I think, my Lord, on the first occasion, my Lord, when we argued, my Lord, I showed that entire correspondence asking, my Lord, for minutes, my Lord, of the meeting. And, my Lord, not only that,
No,
my Lord,
that was not the more important issue. Was you were not here.
20th September.
No, both this and 20th September, not drawing them to our attention.
My Lord, the 20th September and this letter.
Yes.
My Lord, this is.
And this letter was not even included in your whatever you filed before the learned trial.
Yes, because, my Lord, this was perhaps, my Lord, so far as, my Lord, we are concerned, my Lord, may not be, my Lord, so relevant because, my Lord, we have insisted, my Lord, on the question, my Lord, of the minutes.
Very
and this
good.
can't substitute so far as the minutes requirement is concerned.
All right.
That's one. And 20th September, my Lord, has seen, again, my Lord, 20th September is in continuation on my further letter, my lord, which we, the WhatsApp which we circulate. Because 20th, no, 20th is 42 WhatsApp. 20th, my lord, is to the secretary. 20th September is to the secretary.
Correct.
Where also, my lord, we raise the same questions.
Correct. The question is what Mr. Mithra argued,
Yes, my lord.
that the AGM indicated clearly that if any member has any question
Yes.
regarding accounts or whatever, that has to be raised within 20th of September. Only then it will be considered at the AGM.
Yes.
Therefore, on the 20th of September, rightly, the plaintiff raised his objection.
Yes.
After that, why the 23rd September? And this 20th, in that context, this 20th September letter assumes great importance, but it was not placed before us.
My lord, 20th, my lord, I fully, my lord, appreciate what has fallen from my lord. But 20th September, as we, my lord, see it, 20th September, my lord, is part of, my lord, raising it before the AGM. Now, that doesn't stop me, my lord, from also, my lord, bringing, my lord, to the members' attention what my queries are. Because, my lord, I am entitled, my lord, to raise these issues in the AGM as well. That's the purpose of the AGM.
And in the AGM, the issues in your WhatsApp message were not discussed by the plaintiff. The issues raised in his 20th September letter were raised. I have seen the minutes. We have seen the minutes.
My lord, the same, my lord, kindly, my lord, look at, my lord, I'm sorry, my lord, may I just, my lord, trouble, my lord, with the 20th ones, and, my lord, kindly look at, my lord, the 27th.
Anyway, Mr. Banerjee, we have considered, we'll again go through it.
My lord, kindly look at, my lord, 20th. How much money was spent to renovate the men's changing room and bar number 1? That's 20th, my lord, September.
This 8.25 crore, etc., in your WhatsApp message.
That's further.
But that was not discussed. Then why circulate if you don't want to discuss this in the AGM?
My lord, in the AGM, my lord, now, my lord, can you look at, my lord, the minutes? I'm sorry, my lord.
I'm withdrawing my questions, Mr. Banerjee. I'm withdrawing my questions.
No, my lord. No, my lord, it's very important, my lord, that, my lord, looks at, my lord, the AGM itself, where, my lord, 8.25, the figure perhaps, my lord, was not mentioned, but the other issues, my lord, were all discussed in the AGM.
We have seen the minutes because we wanted to see the minutes. Mr. Mithra showed us.
I've shown the minutes, my lord.
Not of the AGM.
Yes.
We at least did not note.
Oh, yes. My lord, that. Oh, yeah, of course, my lord. AGM, my lord, I've shown the minutes. My lord, remember Goenka, that other gentleman, my lord, what the page 500? Yes, my lord, we have shown the minutes.
Yes, you did. Somebody asked some question.
Yes.
But that portion where the plaintiffs.
That is one of the last portion which
that was not shown to us.
Yes.
No.
Lord,
otherwise, we would have marked it, Mr. Banerjee.
No, my lord, perhaps, my lord, then, my lord,
probably was a slip, but.
No, my lord, that whole minutes I've shown. Page about 500. Because, my lord, the plaintiffs, my lord, questioning in the minutes, this is the minutes prepared by them, that faded, my lord, into quite. No, my lord, if, my lord, I wouldn't, my lord, if I had not shown, my lord, I would not have. 515, my lord, it starts. My lord, minute number 5, agenda number 3, my lord, will see. At page 518. Kamal Bhandari, my lord, will recall, my lord, expenses for children's sports and club events. And this, my lord, will remember, my lord, from the 2023 accounts, my lord, in 2024, the whole figures change.
Yes.
My lord, that portion I had shown, my lord, in the balance sheet itself. Where, my lord, that comparative chart I had shown, the 2023 figures, my lord, got changed in the 2024, where, my lord, the 2023 figures are there. And then, my lord, the last portion, 518, my lord, I showed Kamal Bhandari. Then, my lord, I showed 520, Umesh Goenka. Umesh Goenka was desired explanation in respect of capital expenses. My lord will recall that in the accounts through the same was notified. And then, my lord, the last portion came, page 533. Chairman requested Rishi Bajaj to take up Mr. Surana's query as it pertains to finance. That is, my lord, question Mr. Jayasturan inquired how much money was spent. This, my lord, the same question. which my lord is 2020 has that 8.25 figures is not there. But my lord, then after that, my lord, that's what they say. Then my lord, quotations were taken from multiple vendors. So my lord, this is the minutes, my lord, written by them. So they have chosen, my lord, what they want to put and what they don't want to put.
You have challenged the minutes, authenticity of the minutes.
No, my lord, I was not given. I was given only, my lord, at the time, my lord, when, my lord, this matter, my lord, heard.
AGM minutes.
Yes. AGM minutes, my lord, generally, my lord, are posted notice board, but when we came, my lord, to court, my lord, we did not, my lord, have, my lord, the minutes. But I'm, my lord, not on that. My lord, the question is, my lord, on the 20th September, my lord, it's correct. I've written a letter to the secretary. This is in furtherance because we are only concerned with the WhatsApp message. Whether, my lord, I should have, my lord, circulated the WhatsApp to bring to the members' attention that these are the queries I want to raise or I am raising. So, my lord, my submission, my lord, would be, my lord, 20th September, my lord, does not, my lord, change the course of events which transpired with the WhatsApp message. Because I am not hauled up, my lord, tiny similar, if this was material, I should have also been told why have you raised these questions? Because they are very similar. They are very similar. I've raised this to the secretary. Because I've been accused of WhatsApp of 5th September, 26th September. 23rd September. That's my punishment, or that's what I'm charged of. So, I submit, this not being on record really won't make a difference because of the fact that what is that I'm complained of. And in the AGM also, that's why I showed. I'm sorry, if is of the impression that I did not show page 533.
No, but there is no question of separation of the AGM minutes.
I remember also coming to page 533 and
my memory fails me.
No, I'm sorry, it must be but I because this whole minutes I had shown.
Very well.
Whole minutes I've shown. And of course, 9th November, I did not think that will be a substitute.
Both our memories fail us. Anyway.
Then, I'm very sorry, but I'm
But that is really not material. Is there? We have seen.
Very sorry, because I would have shown the full minutes. Because I would definitely show because it is Mr. Surana's he's noticed.
Mr. Banerjee, there could have been a slip. It has happened to me when I was in practice.
I'm very sorry, because I wouldn't doubt Malot's memory at all. But I would have.
But nothing really turns on it. Because a lot does. But
no, in fact, Malot will recall. My repeated submission has been that the issues which I had raised were addressed in the annual general meeting. Malot will recall that submission. That's why I said nothing survives.
Correct.
That's the first submission I made.
That we have noted.
That nothing survives in the cause anymore. Because if I raise issues and you deal with it, that's the opening submission which I made, my lord. If you deal with it, then you can't turn around and then say that I'm still raising it as an issue. My lord, those are my lord our submissions.
The hearing is concluded. Judgment is reserved.
I'm grateful.
List of dates. Give them a copy also.
The list of dates, we have not given the page number.
तो list of dates के तो लाभ नहीं.
কৌশিক আজকে পাঠিয়ে দেবে ভালো করে গুছিয়ে এত কাগজ ছড়ানো লুজ কাগজগুলো সব একটা ফাইলে দেবে ইনক্লুডিং নেট নোট হ্যাঁ আর এই যেটা লুজ একটা অর্ডার কি দিয়েছে এইসব হ্যাঁ
Both the recent judgment of discretionary order is not capricious. All that's required. A discretionary order
whose discretionary
has to be capricious to interfere.
I do not understand.
The judge has given the recent judgment. So, not cut.
No, Mr. Banerjee is a little perplexed.
Yes, I'm very perplexed, Lord. I don't know what. I'm বুঝতে পারলাম না comment.
I'm going to get cultural option.
Huh?
देगा
हाँ, let's say it up.
appellate side up
Fixed matter.
Yes, 12:30 matter.
Please, my lord.
Hmm. দাও কাগজগুলো দাও।
Appellate side fixed matter 12:30. Item number 2 non-commercial.
Millard, before my submission, I would like to submit the update chat for the better appreciation of this honorable court. Update chat.
You are from Delhi and you are from Orissa.
I'm-
Wow, very good. এই কিছু লিখছিলাম কি দেখো তো, নোট ফোট আছে নেই? Sir, sorry, let us allow us to go through the impugned order once we have forgotten everything.
Let's see where I am submitting first. Let's see the present the respondent, a company who is a trading member deals with the various stocks and share.
Hmm.
For his clients, and the present appellant was his client who got himself registered.
Sir, allow us 5 minutes to.
Hmm?
160.
Who was the claimant? Who was the claimant before the arbitrator?
Malas, we were the claimant.
You were the claimant.
SMC was the claimant. If Malas may give me a moment, time,
You obtained an award which he challenged before the city civil court.
please, my lord.
Let's see.
You obtained a money award.
It was a money decree. It was a money award. After a period of 4 years, he challenged it. 4 years, my lord.
Yes.
Lordship,
What are the brief facts? Tell us first.
Lordship. For that, I am taking Lordship's kind attention to page 26, volume 1 paper book. Volume 1, page 26.
Page 26.
Lordship, kindly find para 2 of the said the statement of case of the applicant inter alia made the following submission. Messrs. Sam Global Security Limited merged with the applicant company Messrs. SMC Global Security Limited by Delhi High Court, order dated so and so, as a result of which all the assets and liabilities and business activity of the former company merged with those of the latter. The respondent is a registered client of the applicant since 13/2/2008.
What is this? What are you showing us? What is this?
This is the claim. Lordship,
This is
against
the
that,
plain.
this is the claim made by the TM, decree holder.
Arbitration award. This is
Lordship,
the arbitration
Lordship,
award.
Award.
This is the part of arbitration award. He is reading paras from the arbitration award.
Made by the additional district judge.
Lordship. So this is the arbitrator award, Lordship.
Sole arbitrator.
Then I am coming to
Additional district judge is the arbitrator.
No, my lord.
no.
This is the award. Then the award was challenged before the learned court under section 34. So that is the impugned order before this honorable court.
What is this document?
Sole arbitrator's award, which was impugned before the section 34, my lord. Arbitration award. This is the award, main award.
Arbitration award.
Lordship, I am drawing Lordship's kind attention to that award itself.
Very well. Yes.
Actually, then para 4, after the last transaction 1/7/2008, his statement of account showed a debit balance of 5,89,170 rupees 35 paise. The respondent was aware of the debit balance. This is the claim. So then the applicant used to send digitally signed contract notes and statement to the respondent regularly through the email ID provided by the respondent at the time of the opening of the account. Although the applicant had filed a civil recovery suit for recovery the debit balance before 30 Hazari Court Delhi, it would withdraw the case in due course. So that then let's say kindly come to page 27. Para 3. Let's see here the respondent, the client, appellant before my lord. The respondent in his statement of
Yes.
the respondent in his statement of defense inter alia made the following submission. The respondent only signed the KYC, but all the particulars were filled up by the branch officials of the applicant after his signature. The email ID is not that of the respondent, but of Mrs. Jyotirmay Sahu. The proof can be produced on further request. Even the mobile number mentioned in the KYC is not that of Mrs. Jyotirmay Sahu. The respondent executed his last transaction 1/9/2008 and on the same day settled his dues by handing over cash of rupees 950 to one Ghanshyam Behra, who was the branch manager by then. On 1/9/2008, the respondent gave account closing letter to the applicant, but 8 days after closing the account, the applicant again commenced trading in the actually carried out huge trading, although there was no money in the account. The applicant continued to trade for earning brokerage by setting its own limits. Lordship, and on this, yes, Lordship. As per the bylaw of the NSE, no trading can be done if the client does not have money in its account. Lordship, on this point, I am taking a pause here and drawing Lordship's kind attention to page 109 of volume 2.
Yes, we have read the award. So now tell us why the award is perverse or why should it warrant interference by us?
For that, Lordship, I am taking Lordship's kind attention to page 109 and 110.
Please remember that we are not sitting in appeal.
Lordship.
Yes.
On 1/9/2008,
Sir, the learned arbitrator has dealt with your contention
Lordship,
that you had filed account closure form.
Lordship,
Now there was some dispute or there was no dispute. Let us assume that you did that.
Lordship, only one point I want
Yes.
to
Yes.
show, Lordship. That is, Lordship, kindly come to bottom of that closing of trading account note. There is a note.
Hmm.
Trading account will be closed within 3 working days after checking all required details. Lordship, this is guided by NSE guidelines and this is their guidelines. So within 3 days, the account should be closed after making all the formalities. Lordship, then kindly, I am taking the Lordship's kind attention to page 13A, volume 1. That is the statement of accounts, Lordship.
Yes.
Lordship, relevant
38. 38.
13A, Lordship.
13A.
13A, 13A, volume 1.
Yes.
That's relevant is 1/9/2008. On this day, the account was closed.
Yes.
And he submitted a check of rupees 15,000 and balance 907.99 rupees. That is through cash.
Yes.
Lordship. Lordship, for a moment, before the account status, Lordship, kindly peruse. Nowhere it crossed 1 lakh rupees because they need certain margin to go ahead with the business. But after that, Lordship, when the account is closed, account was closed on, deemed to have closed on 1/9/2008. After 8 days, Lordship, then kindly come to. After 8 days, that is on 8/9/2008, they again started the business. But the guidelines say within 3 days, account should be closed.
Arbitration Act to law. This award is dated?
First, my lord, the award is dated 26 September 2011. After a period of 4 years, 6 months, they filed section 34. The limitation got condoned because they misled the honorable court by showing in a high court order that they approached in a writ petition before.
Anyway, that's irrelevant now. It was condoned. Very well, yes.
Chief, then kindly come to the guidelines.
Actually set aside the court finds the award is issued by patent illegality in the face of the award, provided that and not be set aside merely on the ground of an erroneous application of law or by the appreciation of evidence. এগুলো তো সব evidence. আমরা কি appreciate করবো এগুলো? Yes. And the impugned order is dated? City Civil Court's order?
8th of July 2022.
After the 2015 or 2016 amendment to section 34 had come.
Lordship.
No reappreciation of evidence.
Lordship, at page 38.
38.
Lordship. Lordship, relevant is at page 39. Relevant portion 8.2.4. 8.2.5. Risk management and surveillance. While carrying on transaction on the ATS of
Page 38.
Lordship, 39. Lordship.
39.
Sorry.
Model bylaws.
Lordship. This is the NSE guidelines. Lordship.
NSE.
Lordship.
Sure. Very well.
Lordship, at 8.2.5. Risk management and surveillance. While carrying on the transactions on the ATS of the exchange, every trading member shall be responsible to abide by the requirements relating to risk management and surveillance. As may be, next page, Lordship, as may be notified by the exchange or clearing agency from time to time, the risk management and surveillance function may, inter alia, include payment of all margins, reduction in exposure limits, etc., as may be stipulated by the exchange or clearing agency from time to time. Then 8.2.6. Clients responsible for paying margins. In respect of the transaction executed by trading member on behalf of their clients, the clients shall be responsible to pay margins to the trading member, who shall be required to credit the same in the separate client's account, required to be maintained with any one or more clearing banks approved by the exchange clearing agency, and in turn deposit the same with the exchange clearing agency as may be required under the rules, bylaws and regulation of the exchange. Then Lordship, 8.2.7. Client undertaking to pay margins when demanded by exchange or clearing agency. Every trading member shall obtain a written undertaking from each of his clients to the effect that the client shall, when called upon to do so, provide forthwith margin and or furnish additional margins or deposits in respect of the transactions executed on behalf of the client and or as agreed upon by the client with the trading member concerned, as may be required under the rules, bylaws and regulation. Then comes the very important clause, Lordship, 8.2.8. Client not complying. No trading member shall make any transaction directly or indirectly or execute an order for a client who, to his knowledge, has not complied with the required of depositing money or suitable payment payable, security payable to any other trading member, unless such client shall have made a satisfactory arrangement otherwise with the other trading member. Lordship, in this case, till the 1/9/2008, the day of the closing of the account, the margins were perfectly maintained by the respondent company. But after that, without intimating me, they started going on trading the shares and debentures and making a huge margin for huge debit balance for me when I was ignorant of their business. I thought I have closed everything, that means closed. Within 3 days, they have not intimated anything that your account has not been closed. But after 8 days, they started doing the trading. So, Lordship, my submission on this point, they have cheated the client, my client, and their deceitful activities attracts the section 34(2)(b) Roman 2 of the Arbitration and Conciliation Act, which says, the court finds that the arbitral award is in conflict with the public policy of India. Next, for the making of the award was induced or affected by fraud or corruption, or was in violation of section 75 or section 81. It is in contravention with the fundamental policy of Indian law, or it is in conflict with the most basic notions of morality or justice. I am coming under this point.
That is all, Mr. Counsel.
Lordship, for that I have relied upon three judgments, Lordship. Yes. Written submission I have filed, Lordship, with the
You have filed before us.
Lordship.
For the other.
Anyway, before this division bench.
Lordship.
কিছু আছে ফাইলে এখানে দেখো জাজমেন্ট আছে কটা Yes, what judgments are you relying upon, Mr.? You're relying upon ONGC? No.
ONGC, yes, Lordship. One of the judgment ONGC and Sangyong Engineering. I'm just.
And Haryana Tourism.
Lordship.
Haryana Tourism.
Lordship.
Copy আছে copy
Copy I have given.
Huh?
I have submitted.
আরে কৌশিক তোমার কাছে কপি আছে একটু আগে বললে জাজমেন্ট আছে জাজমেন্ট কপি
Today, the ones which I have filed today, your lordship can. The written notes.
ও রিটেন নোটস এর সঙ্গেই আছে এই তো আজকে ইউ হ্যাভ ফাইলড দিস টুডে
I had extra copies.
which portions of the judgments
Lordship,
indicate
kindly come to running page 91. That is Sangyong Engineering and Constructions Company Limited versus NHI.
yes
Page 91, Lordship.
yes
Lordship, para 30. Here the section 34 2B is defined as the arbitral award is in conflict with the public policy of India. Explanation. For the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if the making of the award was induced or affected by fraud or corruption, or was in violation of section 75 or section 81. Then B, it is in contravention with the fundamental policy of Indian law. Or C, it is in conflict with the most basic notions of morality or justice. Then last, kindly come to next page. That is next page 35, Lordship. Paragraph 35. That is coming under clause B. Lordship, got it?
yes
35. What then would constitute the fundamental policy of Indian law is the question. The decision in ONGC does not elaborate that aspect. Even so, the expression must, in our opinion, include all such fundamental principles as providing a basic for administration of justice and enforcement of law in this country. Without meaning of exhaustively enumerate the purport of the expression fundamental policy of Indian law, we may refer to three distinct and fundamental justice principles that must necessarily be understood as a part and parcel of the fundamental policy of Indian law. The first and foremost is the principle that in every determination, whether by a court or other authority that affects the rights of a citizen or leads to any civil consequences, the court or authority concerned is bound to adopt what is in a legal parlance called a judicial approach. In the matter, the duty to adopt a judicial approach arises from the very nature of the power exercised by the court or the authority, does not have to be separately or additionally enjoined upon the fora concerned. What must be remembered is that the importance of a judicial approach in judicial and quasi-judicial determination lies in the fact that so long as the court, tribunal, or the authority exercising powers that affect the rights or obligations of the parties before them shows fidelity to judicial approach, they cannot act in an arbitrary, capricious, or whimsical manner. Judicial approach ensures that the authority acts bona fide and deals with the subject in a fair, reasonable, and objective manner, and that its decision is not actuated by any extraneous consideration. Judicial approach, in that sense, acts as a check against flaws and faults that can render the decision of a court, tribunal, or authority vulnerable to challenge. That's it. That's it. In this case, all the observation made by the learned arbitrator was in our favor. All the observation, learned arbitrator, but the decision was reversed.
That is all.
That's
We'll come back and dictate the order at 2 o'clock.
May I make my submission?
Not necessary.
Very well, my lords.
কেন এসে দিচ্ছি you both want to go back today?
Please, my
You'll
lords.
go back today? We'll take 15 minutes after. আছে এখানে ডাকো 2 o'clock. We'll come back at 2 o'clock.
Written submissions are already there, relying on 2 judgments.
Well, I'm sorry, but I've also given notice to the other side. But in that other matter, which was in the
Yes, yes.
Yes, I'm so sorry, my lord. I wouldn't have. But I felt a little, my lord. That is there. I've checked the YouTube recording, my lord. It is there. I've referred to it.
You have shown.
I have shown, my lord. It's
It's our mistake then.
I'm so sorry, my lord. I wouldn't have pointed this out. Otherwise, I felt bad, my lord, that I would not have my lord. At least consciously, my lord, I would not. My lord, it's just 15:47.
We know you that, Mr.
My lord,
We know you.
15:47 minutes, my lord, on 12th June.
It's our mistake, Mr. Banerjee. It can happen. It can happen on both sides.
Yes, my lord. I just didn't want to, my lord. My lord, that's
Very
and my
well.
lord, I've also given notice, my lord. If I just want, my lord, I'll take 1 minute of my lord's time. But in the presence of the other side, just my lord, point out that, my lord, 2 letters, my lord, that just
2 letters.
in my lord, because I came in a rush, my lord, I couldn't point out, my lord, with regard to that 9 November as well as, my lord, the 20th. Just that 20. There's 1 letter, my lord. If they're here, my lord, I'll just take 1 minute, not more than that.
They are not here. So can we hear Mr. Banerjee now? Come at 2. First, we will dictate this order.
Yes, after that, my lord.
Millet,
I'm so grateful.
Sorry, Millet, before Mr. Banerjee is here. Millet, in original side, item number 1 to 5, I'm told that in the first call, Millet has released the matter to be taken up by the another bench. Millet, yesterday, Millet, the same prayer was made by Mr. Sharma. We objected to it because, Millet, anyway, the appeal was heard for a day way back in April. It has to be start de novo. So, Millet, kindly don't release, Millet, let it remain in the of yours.
Mr. Dashgupta, you should have been present.
Millet, it's a first call, Millet, I missed that.
Sure. So this was an arbitration, statutory arbitration.
Please, my lord.
A clause in the contract between the parties.
Please, my lord.
Issue. And the award is at page you just showed us, huh? Where page?
It is volume 1, my lord. Award is page number 6. Starting from page number 23, my lords.
Yes, yes. And the contract is here in the paper book. Agreement between the parties. Mr. Das, is the agreement between the parties in the paper book?
Actually, there is no agreement.
No agreement.
It's only a form that has to be filed by the client.
Form has to be filed. That form has an arbitration clause. Is that form here in the paper book? Is that form here?
Form is there? No, I think.
Huge level of preparation.
Mother's account opening form is not there. It is open under the bylaws of SEBI, followed with exchange, National Stock Exchange. So, my lords, these are we both the parties, we both are governed by the stock exchange bylaws and rules.
All right.
My lords, exchange bylaws are there where it has been mentioned that it will be referred to arbitration.
Issue. This appeal under Section 37 of the Arbitration and Conciliation Act, 1996, bracket in short, the 1996 Act, bracket closed, is directed against a judgment and order dated July 8, 2022, passed by the learned ninth bench, ninth Roman 9, Roman 9 TH, ninth bench of the City Civil Court at Calcutta in Miss Case number 1547 of 2016, being an application filed under Section 34 of the 1996 Act by the appellant herein for setting aside of an arbitral award. Stop. Paragraph. The relevant facts of the case are that the respondent company, at all material times carried on and still carries on the business of trading in shares. Stop. The appellant registered as a client of the respondent. This is in 2008. Sometime in 2008, by filing an account opening form. Stop. The relationship between the parties, it is not in dispute. It is not in dispute that the relationship between the parties was governed by the SEBI bylaws. By
SEBI and exchange bylaws, National Stock Exchange.
By the bylaws of SEBI Puro Form Deve, Security and Exchange Board of India, and read with National Stock Exchange. Bylaws of SEBI, read with bylaws of NSE. Stop. Such bylaws contain an arbitration clause. for resolution of disputes between the parties. Paragraph. It appears that disputes arose between the parties. Stop. The respondent herein claimed that an amount of approximately rupees 5.37 5.87 lakh became due and payable to it from the appellant. Stop. The dispute was referred to arbitration. Stop. The parties participated in the arbitration proceeding. Stop. By an award dated September 26, to 2011, the sole arbitrator allowed the claim of the respondent herein, save and except the sum of rupees 22,566, which the respondent herein had claimed on account of litigation expenses in connection with a suit that it had filed in the civil court for recovery of its dues, and which subsequently it withdrew. Stop. The amount awarded was rupees 5,66,604. Stop. Paragraph. Being aggrieved, the appellant herein challenged the said award by filing an application for setting aside. After a substantial delay of about 4 years, stop. The delay was, however, condoned by the court. Stop. Although learned advocate for the respondent herein says that the learned court was misinformed and ought not to have condoned the delay, yet, at this stage, we see no reason to go into that question. Paragraph. The appellant's application under Section 34 of the 1996 Act was dismissed by the learned trial court by the judgment and order impugned herein. Stop. Hence this appeal. Paragraph. Learned advocate for the appellant argued that the award in question is perverse. Stop. All the findings are in favor of the appellant herein. Stop. However, an award was made in favor of the respondent herein. Paragraph. Learned advocate submitted that an account closing form was filed by the appellant in the Bhubaneswar office of the respondent on September 1, 2008. Correct me factually if I go wrong. 2008. Stop.
It's October, 1/8.
Huh?
That is 1/8 2000.
1/8.
19. Yes, my lord. Correct. September.
September.
That's what I said. September 1. Stop. It is mentioned at the bottom of the form that the account would be closed within 3 working days. Stop. However, the respondent instead of stopping all trading activities in the appellant's account, comma, continued with such activities, resulting in huge debit entry in the account of the respondent appellant. Stop. This was wholly illegal. Stop. This amounts to fraud. Stop. Since the arbitral award has been induced by fraud, comma, it is liable to be set aside under section 34. কোথায় গেল বইটা? এই যে। (34) ব্র্যাকেটে 2 ব্র্যাকেটে ছোট b, আবার ব্র্যাকেটে ছোট ii, read with explanation 1. Stop. The said provision is to the effect that an arbitral award may be set aside by the court if it is in contravention with the public policy of India, if it is in conflict with the public policy of India. Stop. The explanation is to the effect that an award is in conflict with the public policy of India, comma, inter alia, comma, if the making of the award was induced or affected by fraud or corruption, or was in violation of section 75 or section 81 of the Act, capital A. Stop. It was submitted that since fraud was practiced in the arbitral proceeding by the respondent, comma, the arbitral award needs to be set aside. Paragraph Learned Counsel relied on the decisions of the Honorable Supreme Court in the cases of Haryana Tourism Limited. A written note last tinte ache, ei tinte diye debe. Paragraph. We have not called upon learned advocate for the respondent to make submission. Paragraph. We see from the arbitral award in question that the arbitrator has come to a categorical factual finding that the appellant herein was well aware that even after September 1, 2008, trading activities in the appellant's account were continuing. Stop. The respondent was prevented from closing the appellant's account since even after September 1, 2008, shares were lying in his account and there was a debit balance which had not been squared off of OFF. Stop. In spite of having due knowledge of the continuing trading activities in his account, comma, the appellant raised no objection. Stop. Therefore, comma, the appellant acquiesced and consented to continuation of such trading activities. Paragraph. No, activity stop. Accordingly, comma, the arbitrator allowed the claim of the respondent herein. Paragraph. We are not sitting as an appellate court insofar as the arbitral award is concerned. Stop. The court, considering an application for setting aside an award under Section 34 of the 1996 Act, as well as the appellate court acting under Section 37 of the 1996 Act, comma, must operate within the parameters of the provisions of Section 34 of the 1996 Act. Stop. The grounds for setting aside an arbitral award are limited. Stop. The setting aside court or the appellate court will not enter into reappreciation of evidence or factual disputes. Stop. Even an error of law within the jurisdiction of the arbitral tribunal may not be interfered with. Stop. There should be minimum interference with an arbitral award. Stop. Paragraph. We find that the arbitrator has passed a reasoned award. Stop. There is no infirmity in the reasons recorded, no apparent infirmity. Stop. It is not the appellant's case that the award is perverse because it is based on no evidence. Stop. Paragraph. The learned trial court also rightly observed that it was not sitting in appeal over the arbitral award. Stop. It declined to interfere with the factual findings of the arbitrator, and in our view, comma, rightly so. Stop. Paragraph. In view of the aforesaid, now, we have considered the decisions of the Honorable Supreme Court relied upon by learned advocate for the appellant. Stop. While the propositions of law laid down in those cases have been reiterated in other cases also by the Honorable Supreme Court, comma, the same do not advance the appellant's case to any extent. Paragraph. In view of the aforesaid, we see no reason to interfere with the judgment and order sought to be assailed before us. Stop the appeal. Application ache? Nahi. The appeal stands dismissed. Stop. There will be no order as to costs.
Grateful, man.
Sorry, sir.
That's it. The soonest limit yet to be forward after receiving this.
আপনি বলুন তারপর আমি কল করব।
If your lordship takes up the continuing matter, my lord, and I'm sorry to mention, my lord, item number 1 to 5 of.
So it was mentioned by Mr. Dashgupta, Mr. Sen. We are of the view that the other bench, it's not the only learned counsel. So we have released it to be assigned to that other bench.
The only difficulty, my lord, which would be, my lord, the
No.
matter was not.
We still remember the Jodhpur property. It was taken out of the schedule to the execution proceeding. That bench would remember much more. Here, my sister never heard it.
Only thing, my lord, your lordship is the regular bench, my lord. Your lordship is hearing the matter almost taking
Mr.
the
Sen.
list every day.
No.
Otherwise, my lord, we'll miss a chance. There were only once, maybe once a month, Friday, your lordship will be sitting.
You'll be surprised. You'll be surprised. Have some patience and faith and just see what happens.
Lord, I'm extremely grateful, my lord, for my lord,
Yes,
giving
where's
me
your
this-
other side?
Yes, my lord, we have given my lord, everyone.
Mr. Mitros, 2 documents they wish to point out. So is it fine?
My lord, first, my lord, that I'll just be, my lord, the briefest possible. I'm sorry, my lord, in the response I can, my lord, just show it immediately. First, my lord, in the transcript, my lord, page 467 and 473, both places, my lord, they say minutes of the meeting will be done. In the transcript itself, my lord, which is, my lord, there on record of 8th November 2020.
That was pointed out to us.
My lord, that's one.
Yes.
Second, my lord, the 9th November 2024, which my lord thought, my lord, was a question of, my lord, suppression. My lord, we have not waived our right, my lord, asking for the minutes. In fact, thereafter also, my lord, 24th November, even, my lord, immediately thereafter also, we have gone on, my lord,
My
asking for
note
the
to the
minutes.
note to the.
I think 332 টা মতো।
Even subsequently, you demanded.
Yes, my lord, I do not give up, my lord, my right to ask for the minutes. So what I'm saying is, my lord, the transcript also said minutes will be placed before the executive committee. They also promised to me, as well as, my lord, thereafter, my lord. So I'm saying video recording cannot be a substitute. That's why 9 November, my lord, may not be relevant in that context. 332, 333, 334, everything, my lord, continuous asking, my lord, for minutes and also explaining that, my lord, I've got the video, but that is not good enough. And it says, as I'm just reading, my lord, one, I'm so sorry. As promised in the meeting held with MRC on 8 November, minutes of the meeting is yet to be forwarded to me. You are requested to forward the same to me, enable me to answer the queries received. My lord, those are, my lord, the documents. So 9 November, my lord, is not, my lord,
All right.
relevant. My lord, just another thing. My lord, so far as, my lord, 20th September 2025 is concerned, that's the other
Yes. Yes.
my lord, letter which was, my lord, first, my lord, in rule 49, my lord, nowhere does it say that any question with regard to accounts have to be given before. Rules do not say that, because it is not done in every meeting be it incorporated company, be it club, questions with regard to when the annual accounts are read out, questions are read or questions are raised at that meeting itself. And 20th September was not an issue. Therefore, it is a non-disclosure or non-producing will not make any difference, because 20th September was not an issue. It started with 23rd September 2024. And this is also not. And these grounds were also, even in the impugned order also, these grounds are not which have been held to be at all relevant in refusing me the ad interim order. And the AGM was uncontested. The AGM was an uncontested. That I didn't know. AGM was an uncontested election anyway. So only accounts being raised, I don't think that would have made a difference.
That is all, Mr. Banerjee.
And lastly, I'm sorry, I perhaps that I saw what I mentioned, I'm mentioning. I again looked at the YouTube recording. I'm so sorry, perhaps I don't know why but it is there.
All right.
And at
It
50.
is now.
I'm grateful, and I'm sorry, really for troubling again. I'm grateful.
Item number 7 and 8.
কপি আছে তো ব্ল্যাক কপি আছে
I'm being led by Mr. Anuj Singh. My learned senior friend would be arguing today. So
What do you mean? You will not argue today?
let's let him continue.
আর্গুমেন্ট করবি তো ভাই
হ্যাঁ
Well, the short point involved in this appeal is that whether a dispute arising out of a family settlement can be a commercial dispute. So as
But
to
you are Ramji or Saurav?
that I am Ramji. Can be a commercial dispute. Now, well, admitted facts are that the suit was filed trying to enforce a negative covenant, which is contained in a document titled as the family settlement.
Who filed the suit? You.
My client filed the suit. The subject matter of the family settlement is partition of the family business and properties, which includes both residential properties and business properties. I shall show that between 5 sons of the family patriarch who had set up this business, which was started initially as Sindaram Savarmal. It's one of the well-known brands in dry fruits. Purport of the settlement is that each of the 5 wings will use the mark Sindaram Savarmal with its own prefix or suffix. That is, I am Ramji, I am using as Ramji Lal Sindaram Savarmal.
Oh, that within 1 kilometer or something?
Yes, yes. I am just indicating. My learned friend's client, my lord, being the son of one of the brothers, this is the next generation, my lord, they were using it as Sindaram Savarmal Mewala. Huh? Mewawala, and so on and so forth. All the 5 wings were carrying on business with their respective marks, and there is no dispute arising out of any mark. This is very important. The issue which arose leading to the filing of the suit was that out of the various properties, my lord, the Cotton Street, my lord, in Cotton Street, there were 2 showrooms. One was originally Sindaram Savarmal, and adjoining that, it was being carried out in a different name, Hanuman Stores. So, my lord, Sindaram Savarmal comes to me, that is my client, and Hanuman Stores goes to my learned friend's client.
Under the settlement.
Under the settlement. And when there is no dispute, both are carrying on business of dry fruits. There is no dispute with regard to that. The father dies. My learned friend client's father dies.
His family settlement took place during the lifetime of the father.
Yes. Now, my lord, after the death of the father, the son comes into the picture. And my lord, one fine day surreptitiously changes the name Hanuman Store.
Oh, father meaning your brother.
Yes.
Father meaning your brother.
My brother, so long my brother was there, my lord, of course, they have tried to make out a case that even during my brother's lifetime, but that's, be that as it may, even if I assume their case to be correct, it doesn't make any difference. But Hanuman Store name changes to Sindaram Savarmal Mewawala. Squarely hitting, my lord, the clause which fell from your lordship, that, my lord, there is no restriction that you can open any shops in Kolkata. You are using your mark. You open shops Sindaram, Savarmal, Mewawala, everywhere. The very next shop is there. That is changed. When we write to them, my lord, I show the contemporaneous letters. My lord, why I am saying that those reply will be, that is of course on merits, provided I succeed on the jurisdictional aspect first.
You filed it as a non-commercial suit.
Yes. But I file it as a non-commercial suit because, and I claim relief only against my learned friend's client to the extent of, my lord, enforcing the negative covenant. The contemporaneous documents, my lord, do not disclose they have any issue. My lord, now, my lord, before the judge, my lord, later it comes in, I shall show. Later it comes in, they are saying that I have not got this, I have not got that. I'll come to that. I'll deal with that. That's really an afterthought. And that will also be of no, because I can undertake today, if they are sitting on a property which is to come to me, and I am on a property which is to go to them. Today it can be exchanged, but they will not do it. They have taken it as a defense. But that's the secondary hurdle. Well, the first question is whether, my lord, a family settlement can at all come, a dispute emanating from a family settlement, which also deals with commercial properties, can be a subject matter of a commercial dispute within the meaning of the Commercial Courts Act.
This is within the family, Mr. Anuj Singh. Can't it be settled? Mediation, have you tried mediation? Families dispute, nephew, uncle, nephew. Mr. Chaudhary, these are the types of matters which should ideally, often, muchka ladai hota hai.
Well, I don't, what is falling from your lordship, I can understand, but my lord, things have gone to the extent, in spite of separate accounts and all that, my lord, no separate accounts are not being given to us. Transactions in volumes are being done on cash. We have videographed.
This is beyond, my lord, the brief.
We have
my lord,
videographed. I am only indicating. We have videographed proof.
Would you tell your respective clients that the court has observed that since this is really a dispute between family members, the court would be very happy. Otherwise, we'll decide what is there. It's our job and duty to decide.
It's fallen from my lord, I still certainly try that.
To sit. I have instruction. He is saying I am ready to sit. I don't mind. But
no, we are thinking of a professional mediation. A trained mediator. Otherwise, sitting may not help.
The only thing is, I'll be very candid. Every time settlement talks, they are offering money. But my client is saying you can't have a shop room just beside me having the same name. That is a basic point. But let them sell dry fruits also. Hanuman store, they were selling dry fruit. But my lord, they can't have the same name, my lord. Lordship knows in the passing of actions, my lord, we say visually deceptive action. So if that is, my lord, if they bulge from that, then my lord, any mediation or settlement. If they don't, I am not interested in money.
What we are saying, a trained mediator may actually facilitate the settlement.
I don't mind, my lord. I should certainly communicate this to my client, my lord. I'm open to this, my lord.
Come back with instruction tomorrow itself.
Very well.
Tomorrow we'll refer this, we'll keep this pending naturally and refer it.
But my lord, more importantly, my lord, this point of, my lord, family settlement, my lord, with greatest of respect, my lord, the learned first court has an impression, my lord, following the Supreme Court decision, that wherever the user is commercial, my lord,
Which one? HON'BLE?
HON'BLE, wherever the user is commercial, lock, stock, barrel, it's being referred to, my lord, the commercial.
We may not have to decide the point in this suit if the mediation succeeds.
This judgment will hang on. This judgment will remain, my lord, till that is happening.
Come back tomorrow.
Of course.
Come back tomorrow. Lekho to. After having heard Mr. Chaudhary, learned senior counsel appearing for Ramji Lal Agarwal, the appellant in APOT 99 of 2025, we are of the view that there is an element of settlement in this matter. Stop. The dispute is simple and between family members. Stop. We are of the opinion that the parties should resort to mediation, should resort to mediation to iron out their disputes and differences. Paragraph Mr. Chaudhary, learned counsel for Ramji, on instruction, says that his client is agreeable to go for mediation. Stop. Mr. Anuj Singh, learned counsel representing Saurav Agarwal, being the appellant in APOT 95 of 2025, seeks a day's time to obtain instruction. Paragraph, list the matters once again tomorrow. It action is 7 আর 8.
For hearing, item number 9.
Mr. Banerjee had made submissions.
Yes.
Now he's on legs.
Oh, yes.
That order to rule 2 and the commercial.
Yes.
We come back on Monday, my lord.
No, they were making submissions.
Yes, my lord. But then Mr. Banerjee is on legs, so my lord. Again,
he's also not here.
But he's not here, but then.
Not today. No, Monday.
Lord, Monday, if it could be taken up, my lord, then Mr. Banerjee.
My learned colleague is on his legs. Just pass it over, your lordship.
Everybody on their legs. He's saying Monday.
Otherwise, my lord, again it will be a break, my lord. I'll have to embarrass myself, my lord.
Since arguing counsel for both the sides are not present when this matter is called on, let this matter stand adjourned and be listed again on Monday date, retaining its position.
Deeply grateful.
Item number 12.
Pass over.
Item number 13.
Same. 13.
For the respondent, that bunch of matters, Lord, which relates to transfer.
Oh, yes. Transfer. Hey, কিন্তু কি করে হবে? Mr. Kaur, who is appearing for the
petitioner, your lord.
You see, those bunch of matters are actually heard in part by that bench.
Oh, I see.
So we release this matter from our list, have it assigned.
or otherwise, my lord, since your lordship, this is the other bench.
This is
That is also your lordship's.
yes, but that is no.
No more.
No more.
I see. Very well. Then kindly, my lord.
Hey, लिखे ना तो 13 this appeal arises out of an order directing transfer
Yes.
of a winding up proceeding to the National Company Law Tribunal.
Last order.
Stop.
June 16.
A similar point is involved in a bunch of appeals which are heard in part by another division bench, brackete Amar আর ওমনারায়ণ রায় সাহেবের নাম দাও, being APO 194 of 2023, etc. Paragraph. Accordingly, let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction.
Because, my lord, there is an order passed by your lordship on 16 June, where my lord has already directed that this matter to be listed along with those matters.
It
But
slipped my mind completely that.
that's a different way.
Yes.
Very well, Lord. We'll get it.
আচ্ছা একটা অ্যাড করে দাও তো, ইনভলভড উইথ, বলেছি না, ইনভলভড ইন এপিও এটসেট্রা, ঠিক আছে? So in our view it will be convenient if this matter is also taken up by that bench along with APO. Paragraph. Accordingly, let this matter stand released and be placed before the chief.
Grateful.
Appeal from order, item number 14.
My lord, item number 14, my lord, I am for the appellant, my lord. I am very sorry, my lord. I was in the charge of middle of my argument, my lord. My lord, I have fallen sick. Therefore, my lord, I have to pay for an accommodation before your lordship.
Tell us when you want it.
My lord, next Wednesday, my lord.
Since my learned friend has fallen ill, I cannot say anything. But one thing may I pray for one thing, subject to lordship kind approval. Kindly fix up the time subject.
Learned
Lordship,
advocate
that
for,
matter 2006.
yes, learned advocate for the appellant seeks accommodation on the ground of ill health. Paragraph. List this matter once again on সামনের বুধবারে ডেট দিয়ে দাও, retaining its position.
I'm deeply
obliged and very sorry, my lord. In a continuing matter,
Why should you be sorry?
No, in a continuing matter, my lord, I should not have asked for time. In fact, I have tried to go yesterday court and that has aggravated the problem, my lord.
Recover fast and then come.
Deeply.
It will retain its position.
Have Horlicks. Yes. Yes, retain its position.
I'm deeply I have taken also the judgment which has been placed by lordship.
Deeply.
Item number 15.
I appear for the appellant, my lord,
I
as
appear for
addressing
this
your
one.
lordship.
Yes.
Last occasion.
My lord, in this matter, my lord, Mr. Devnath Ghosh is appearing, my lord, and Mr. Shumaba Ghosh is appearing, my lord. Kindly, my lord, grants a short passover, my lord.
Why? Where are they?
My lord, they are on their way, my lord.
On their way, let them come. Let Mr. Chatterjee proceed. You tell them that we have taken up the matter so that they come fast.
Sure, my lord.
Tell them otherwise you may have to argue the matter.
Sure, my lord, I'll just message.
Oh, point of maintainability.
Yes.
Yes.
My lord, point of, I would rather put it a point of lack of jurisdiction of the learned single judge, because the order was passed in the non-commercial division
Right.
in respect of a suit which was transferred by operation of law to the commercial division on the date the impugned order was passed. So my submission is, my lord, that application could not have been dealt with or entertained in the non-commercial division on the day the impugned order was passed, because the suit had been transferred to the commercial division, number one. Number two is that there is a very serious consequence of that, because once the suit gets transferred to the commercial division, I can take, in the matter of filing of a written statement, which is the subject matter of the appeal, my lord, I am entitled to the benefit of section 15 subsection 4, which your lordship perused on the last occasion, where the regime is totally different. And the section is construed by the courts, by the various high courts, even including our court, say that when a suit is transferred, I am entitled to a fresh timeline for filing of a written statement as a matter of course. So that has a serious consequence also, apart from being without jurisdiction, because a commercial matter could not have been entertained in the non-commercial jurisdiction on the day the impugned order was passed, because it stood transferred to the commercial jurisdiction. And my submission is that it is rendered a quorum non judice, which point total lack of jurisdiction can be taken up at any point of time. And I am covered by authorities on that.
My lord.
So your application was dismissed.
My application for extension of time to file written statement was dismissed, but dismissed at a stage and on a day on which the suit originally filed in the ordinary original civil jurisdiction stood transferred to the commercial division.
With leave of my senior friend, my lord, I would like to place the order of the single judge, my lord.
I have apprised my lords about that, about the settlement.
Where
About
there was
the settlement. I have told
settlement was to be entered into between the parties.
Yes.
Now, my lord, the thing is, once a talk of settlement is to be started, now the party's apprehension is, since settlement is going to happen, then why the litigation?
So, Mr. Chatterjee, he is saying there's still a chance of settlement.
Yes, my lord.
Therefore, he is asking for adjournment. Otherwise, settlement will suffer. The process of settlement will
submission
suffer.
was made on the last occasion.
Yes.
Same submission was made. My response was that while it is true that if the settlement succeeds, this hearing may be rendered infructuous.
Yes.
On the other hand, if the settlement fails, this being a commercial proceeding hanging for quite some time, we can make some progress on this front, because ultimately, if the settlement fails, this question will be one of the relevant questions in the case management process also.
Mr. Chatterjee, we'll decide then. Let us hope that the settlement succeeds,
That's what my
at least for our sake.
that's grateful, my lord.
How long? 2 weeks. You see, if we grant you a very long time period, you will never settle.
My lord, on 3rd of July, the single bench has kept the matter.
Hmm.
I hope by that time we would be able to reach on a conclusion of settlement.
When should we keep it? Tell us.
My lord.
Since my learned friend, yes, the learned judge has fixed it on the 3rd of July, although the learned judge has said that the settlement is to be completed within 3 weeks from Monday, that is, I think, 16th of June.
Yes. 16th of
So
June.
immediately after that, my lords may keep.
Immediately after that, my lord.
30.
I follow date more.
Would like to place.
You can keep it on the 4th of July.
My lord.
4th of July, very well, sir. Right. My lord, one indulgence I am seeking, since Mr. Dutt is assisting me, he is coming from Delhi. Can it be fixed on 4th of July at some time, Millard, so that we can make some progress? Because he has been waiting here with me since Monday. So on 4th of July, if it could be any time, 11:30, 12:30, 2, 3, 3:30.
3:30.
3:30.
Grateful. Grateful.
Friday, second half, this bench is not available. The regular bench is not available.
Okay, like, yes.
ইয়ে করে দাও, ঠিক আছে, তুমি ইয়ে করো, 12:45.
12:45. No, 12:45. 12:45. Very
grateful.
Learned advocate for the respondent says that the parties are trying to settle the matter. Stop. The learned single judge has posted the matter on July 3, 2025. Paragraph. Let this matter stand adjourned and be listed again on July 4, 2025, marked 12:45 p.m.
Lordship, deeply.
My lord, I'm.
4th of July.
This is PF. It's called PF. Photo finish. You will see.
The success of the photo finish will depend on the photographer ultimately. That's
Item number 16.
আজকে যাইনি চাই চমকটা দিতাম আর ধরেছে আমার গুণধর ক্লার্ক আমি এমনি করি ডেটটা দাও এটা আগের বার দিয়েছিলাম তো আপনাকে
এই ওটা কি কটা পেপার বই? 6টা.
The point is very short, my lordship will not get
Yes, no, otherwise,
irritated by the
no, we were thinking of adjourning it for 2 years.
no, my lord, my client 2011, my lord, is going on. Very point is very short.
$34, appeal from 34.
Well, there is a convenience compilation if lordship only takes that. Two convenience compilations. I'll give the actual pages and I'll refer to that. Well, the list. My lord permits, my lord, I have prepared a list of dates. তোমাদের দিয়েছিলাম তাহলে ওই বেঞ্চে দিয়েছিলাম না But I'll indicate what is the point, my lord. The dispute arose out of an agreement, my lord. The issue was whether there is an agreement to pay service tax. My clients, ABG, they are involved, my lord, in rendering services, my lord, shipping services at the harbor, my lord, whether, my lord, the services involved service tax component included in the contract or not. That was the moot question in issue out of which disputes arose. That was referred to the arbitrator. The arbitrator construed the correspondence and the contract and the post-contract correspondence and conduct and comes to a finding that there is a agreement to pay service tax which was agreed upon, which was acted upon.
Agreement to pay
Reimburse service tax.
Reimburse service. CPT Kolkata put trust to you.
Correct. Now, my lord, and an award was passed. A monetary award was passed in favor of my client, my lord, aggregating to excess of 8 crores, around 8 crores and odd at that point of time. Lord, in section 34, Lord, with greatest of respect, my lord, the learned judge has, my lord, done what should not have been done in section 34 by, my lord, construing a contract between the parties, by, my lord, construing the correspondence and ignoring the written terms of the contract itself. So, my lord, this is the short point because, my lord, the learned judge has set aside the award by holding that there is no contract for payment of service tax between the parties. So this is where, my lord, we stand. My lord, papers are voluminous, but, my lord, we will be concerned with, my lord, only 6 to 7 documents, not more than that. My lord, kindly takes up the list of dates. Lordship will get the factual background in a nutshell. Lord, the reference to the pages on the right hand side is not apropos the convenience compilation, but, my lord, the actual documents in the paper book. I'll also, my lord, I'll also, my lord, put it, my lord, separately in the same list of dates, my lord, the pages of the convenience paper book also, my lord, but as of now, kindly take the list of dates as it is. Well, the tender is floated on 13th of June 2003. Oh, I'm sorry, my lord, the convenience compilation is also, page numbers are also mentioned. Both pages lordship will get. So, my lord, 13 June is the tender. Then, my lord, 5th of August, lordship will find. My lord, I read this. Intending bidders were in paragraph 9 on the point of service tax at 8% now in vogue on all contracts being raised. The respondent clarified that all statutory taxes, duties, etc. in vogue will have to be included in the rates quoted by the prospective bidders. This is, my lord, as on 5th of August. Then 17th September, letter issued by respondent bearing reference so-and-so along with so-and-so with an enclosure. All decisions and clarifications on points came up in the pre-bid meeting dated 5th August 2003. So-and-so, it was also intimated enclosure shall be treated as part of documents. Well, these are pre-contract correspondence, which was construed by the learned judge to arrive at a decision that there was no contract between the parties, ignoring the actual terms of the contract, whereby a specific letter is made part of the contract and will not acted upon later on. Will not right from 5th of August 2003, right up to item 1, 2, and 3, these are pre-contract correspondence. Well, the important document with which we are concerned is a letter dated 6th October, item number 5 of the list of dates. Lordship will bear in mind there are two letters of 6th of October. One is a letter, my lord, item 4 is of no consequence. It's a letter written by my client. But what is important is the letter of 6th of October.
Your client, Road Wings International.
Yes, my lord. Earlier it was Road Wings. The name later changed to, my lord, ABG Kolkata Container. 6th of October 2003, the respondent issued a letter bearing number so-and-so to all bidders intimating that service tax at 8% shall be payable extra on the amount payable as per rates quoted by the subject tender. Lordship finds that. So this document, my lord, Lordship will find at page 40 and 41 of the convenience compilation. Well, kindly have a look at this document.
40 and 41
of the convenience compilation, my lord, volume 2.
80.
Oh, convenience compilation to nahi ache duto erokom choto choto ache.
This is convenience compilation.
So that is, my lord, 40 and 41. But volume 1 ta din. My lord, it's better lordship looks from the actual paper book, it will be easier. Because in the event my learned friend refers to the actual paper books, then lordships will unnecessarily have to.
I'll be, of course, it's his convenience called compilation. So I will, of course, refer to many documents from the paper book.
He will not
Why?
see my convenience.
You don't want
Make
to.
it inconvenient.
Yes, you'll make it inconvenient for us.
So inconvenient.
For us.
Yes, my lord. So that your lordship, I'm not the only one who suffers from spondylosis. Ensure that your lordships are also affected.
Page 70. 70A is the type copy, page 70. Page 70, lordship will find. Lordship marks the date right at the top, 6th October 2003. Because well, this document is very important. This document has been taken into account by the arbitrator and has been read along with the main agreement. Well, this is prior to the tender, my lord, being opened. And all the bidders, 6 bidders, my lord, all of them are being addressed. My client is item number 7, my lord, at the top as the addressee, AVG Heavy Industries Limited, Mumbai. And I read it, my lord. Further to this office letter of even date on the subject matter addressed to so and so.
ABC Heavy Industries.
Yes.
You are ABG Kolkata Container
The
Terminal.
name changed.
How many times your name changed?
Twice or thrice.
So Road Wings International, then ABG Heavy Industries Limited.
Now ABG Container.
Private Limited. From public you have become private.
But that is because of that time deemed public.
Deemed public.
Now, my lord, another name, Star something. In the execution application, we got another name.
Further to this office letter of even date on the subject matter addressed to ABG with copy to capstan so and so, so and so and so and so, please be informed that service tax at 8% shall be payable extra on the amount payable as per the rates quoted by you for the subject tender. You are therefore requested to kindly work out your competitive offer, keeping the above in due consideration. So in the pre-bid meetings and earlier correspondence, what was said that you quote along with all taxes, service tax and all, this is a variation, and in accordance to that we were asked to quote. This is a letter, Lordship marks the date 6th of October 2003. Now Lordship goes back to the list and kindly see copies to the Secretary, FA and CAO, Traffic Manager, Chief Mechanical Engineer. This is, my lord, for their information, because, my lord, this change was done. Page 71, Lordship will find Chief Engineer right up to, my lord, 9 officials were given this for information, because since this decision was just prior to the Puja holidays, everybody was informed over here.
ABG Heavy is not your client, Mr. Chaudhary. Road Wings International, number 2. Look at the letter.
Yes, Road Wings was the earlier name of ABG Container.
You said ABG Heavy Industries.
I am sorry. Yes. My lord is right. I made a mistake. Road Wings International subsequently became ABG. I'm sorry. Yes, I first said item 7. It's a mistake. So, my lord, this was the letter of 6th of October, where, my lord, the tendering authorities, prior to opening of the tender, squarely clarified that service tax of 8% will be payable extra. And this 8% figure was, my lord, as per the prevalent service tax rate at that point of time. The GST regime had not come. So 8% was the prevalent rate of service tax at that point of time. Now, my lord, kindly come back to the list of dates. Item number 6 is the letter of intent which was issued by the respondent in our favor when, my lord, I became the lowest bidder. Now, this also Lordship will find at page 87 and 88. This becomes important because, my lord, the learned judge has construed this letter ignoring the actual contract as saying, and it was their contention which has been upheld, that since the letter of intent does not refer to the 6th October letter, therefore it cannot be treated as part of the contract. Though, my lord, in the formal contract, the 6th October letter is expressly mentioned as being treated as part of the contract. Well, kindly have a look at 28 January 2004, 87 to 88. This is, you are successful bidder, you are given the contract. Page 87 to 88. Well, the typed copy is at 87A. The subject matter, Lordship will find letter of intent for supply, operation, maintenance of 2 numbers of mobile harbor cranes, so and so, so and so. Now, in this reference section, well, the Some of the earlier correspondence have been referred to up to, my lord, 2004. Up to 2004, my lord, January 2004 has been referred to. Please be informed that your tender, along with all subsequent clarification confirmation as referred to above for the subject work for supply of 2 numbers of new mobile harbor crane and other support equipment for so-and-so on own operate and maintain basis for a period of 10 years have been found acceptable by the KOPT administration as approved by the competent authority. You are therefore requested to arrange execution of bank guarantee for a sum of 85 lakhs and contract agreement within the stipulated time of 30 days. So, my lord, I provide the bank guarantee, a formal contract agreement will be executed. Now, my lord, it was my learned friend's contention, which has been accepted, that the letter of intent does not refer to the 6th October letter. And that's an admitted position. I don't dispute that factually. Then, my lord, I deposit after my bid is accepted. I deposit whatever is required, 85 lakhs and odd. And now comes the formal contract between the parties. That is, my lord, 2nd of April, item number 8 in the list of dates, page 89 to 92. Page 89, my lord, Lordship will kindly open up the volume 1. Kindly marks the date. The agreement date is 2nd of April 2004. So, my lord, on 6th of October comes the clarification that service tax will be payable extra. Then, my lord, we have the letter of intent which comes in my lord, August. I'm sorry, the letter of intent is issued, my lord, which comes in January 2004, 28th of January. And then, my lord, comes the formal contract agreement after I deposit whatever is required, 84 lakhs and odd. Lord, other terms and conditions are not very relevant. My lord, kindly comes to page 90, item number 2. Well, 90A is the typed copy, but I would, my lord, there may be a typographical error to avoid controversy, my lord. Let me read it and then I'll come back to the typed copy, page 90. My lord, item 2, my lord, kindly marks it. The following document shall be deemed to form and be read and construed as part of this agreement. Lordship got that? Now, my lord, in that, Lordship will find, my lord, there are various categories. Kindly see, my lord, item C. The following correspondence or document by which the contract is added, amended, varied, or modified is in any way by mutual consent and shall be deemed to form and be read and construed as part of this agreement. And will kindly see
Roman 6.
Roman 5.
5, yes.
Well, 5 and 6, both are 6th October letter, but we are concerned with Roman 5. Well, item 6 is a letter written by Road Wings. That is, my lord, me in my predecessing name. Item 5, letter number makes CTM MIC dated 6th October 2003. So, my lord, not only, my lord, it was clarified prior to the bid. After a letter of intent is issued, when the formal contract document is executed between the parties, the correspondence which was exchanged prior to the bid was formally made part of the contract, including the document of 6th of October 2003, which is at page 70. That's the page 70 document. Because, my lord, the port authorities, my lord, first tried to raise a suspicion on the document. Then, my lord, when the original was produced from their custody, which has been recorded by the arbitrator, my lord, there was no doubt about the genuineness of the document. The arbitrator has noted this document was being Copies have been forwarded to all the higher authorities and the lower officers. Aspersion was sought to be cast on the signing officer who has signed on behalf of the port as if he has entered into some unholy nexus with me. All those were negated. And my lord, award was passed holding that there is an express agreement that 8% express. The only thing additionally done was, well, at that time the rate of service tax had changed from 8 to enhanced.
To 10.3, very good.
10.3. Well, whatever was the rate, well, at that point of time, the arbitrator had said that you have to pay and that. So, well, this is the main contract between the parties which was expressly agreed. Now comes, well, after this, well, straight away kindly come to the work order, which is 18th May, item number 9. So, my lord, I first showed to your lordship pre-contract correspondence, item number 9. Well, this lordship will have to take volume 3 to volume 3 ta din. And in fact, the relevant documents may be flag marked also in lordship's. This paper book, well, it's flag marked.
আমরা তো প্রথম শুনছি এটা। You argued this matter before another bench?
This was, my lord, I had completed my arguments, but my lord, my learned friend could not, and my lord, one of the learned judges retired. That point of time, Justice Subroto Talukdar was, lord, taking up these matters. It was assigned before that bench, and my lord, other judge, my lord, Lord, 18th of May, my lord, 224 to 229. Document of the contract of
This also refers to that letter.
yes, my lord, and it not only refers to, my lord, it records that this work order, reference above and submission of bank guarantee so and so. Then, my lord, lordship will come to 225, execution, page 225, and execution of agreement on 2nd April 2004. Undersigned is pleased to place this order with you for the subject work of a period of 10 years with effect from date of commencement of work, container handling so and so at 89 per move per activity, basis of mobile harbor crane, then bank guarantee so and so. You are also requested to arrange detailed work schedule. Major term, kindly see para 5. The major terms and conditions governing the contract or order are mentioned in separate sheets enclosed here too. And this is signed not only by the chief mechanical engineer but another officer. And this is in the major terms and conditions which start at page 226. But I just show you. At page 228, at page 228, clause 11, the payment will be made every month within 30 days from the date of submission of bill. I'm sorry, page 228.
Yes.
The payment will be made every month within 30 days from the date of submission of the bill, complete in all respect. Service tax at the rate of 8% will be payable extra on the amount payable. The online accounting dealing may be examined so and so, but I am not concerned with that. Relevant is only service tax at the rate of 8% will be payable extra. The Lordship will come back to the list of dates. The list of dates, my lord, I was at item number 9. Item number 9 I showed to your Lordship. Now, my lord, kindly come back to the list of dates. Item 10, my lord, the name changes to ABG Kolkata Container Terminal Private Limited in between 2005 and 2006. Now, my lord, most importantly, not only, my lord, it was agreed, but I was paid service tax at 8% extra. And, my lord, when it enhanced to 10% and 12% from April 2006 to March 2007. I was paid the service tax extra 8%, and when it was increased to 10% or 12%, whatever the applicable rate was. Then, my lord, similarly 2007, 2008. And these are, my lord, admitted position, factually admitted that I was paid on that date. The corresponding pages are there. I am not troubling your Lordship. This is admitted. Because later on, when another officer comes, a U-turn is made. I'll come to that. Up to item 13, Lordship has seen 12.24, then 10.3. These are paid. So from 2006 till 2009, I am reimbursed with the service tax initially at 8%. Subsequently, as and when it rose, whatever was applicable on that particular relevant year, 10%, 12%, I was paid. Then, item 14. Till June 2009, the respondent reimbursed the appellant all service tax at the then prevalent rate, but thereafter the respondent has not been paying and or reimbursing to the but thereafter the respondent has been paying or reimbursing to the appellant service tax at 8% and not at the prevailing rate of 10.30%. So, my lord, in 2009, the initial issue was that someone came, change in officer, opined that agreement is only 8%. So we will pay only at 8% and stop paying at the enhanced rate. This is the first. Then, my lord, we write a letter, my lord, item 15 of the list of dates. On finding that service tax while processing monthly bill of June was added as 8% and not 10%, the appellant wrote a letter to the respondent to pay the service tax at the prevalent rate on the bills calculated. This is for 2 crores and odd. Because well, this is, well, the difference 8%. What I am entitled to is 10%. Difference was 2 crores. 10.3 and 8, well, difference was this amount. Then, well, when I write this, then comes another change in stand of the Port Trust. Complete shift, saying that you are not liable to pay service tax at all because there is no agreement between the parties to pay. This is, my lord, item 16. I shall show this letter to your lordship. And this is where the dispute starts. 31st July 2009, the respondent issued a letter to the appellant intimating they are not liable to pay service tax on excess of 8% and deducted 2 crore 14 from the bill of the month of June on the above alleged ground, and further claimed 4,98,000, failing which performance guarantee shall be invoked.
Not followed. They didn't say that they are not liable to pay at all. They say that.
I'm coming to that. That's
Yes.
another letter. So, my lord, the differential amount, whatever they have paid, they are deducted, and whatever they are paid in excess of 8%, first they deduct that. Now, kindly have a look at the letter 148. But I'll only show 4 or 5 documents. That's why I'll do the matter on list of dates. 148, volume 2. Volume 2. The earlier excess payment made of 2 crore 14, which was above 8%, that was deducted. For 2 crore 14, amount was deducted. Adjustment of excess service tax paid amounting to 2 crore 14, 27 lakh 220 from the invoice of ABG. The amount of service tax paid is in excess of 8% has been calculated on the basis of bill forwarded by you. Same comes to 2 crore 14. It is observed that an amount of 2 crore 14 has been recommended for payment of invoice of yours from the month of June after deduction of so-and-so as real. It may be mentioned an amount of so-and-so deduction. So initially, 2 crore 14 is deducted. Before I go back to the list of dates, since my lord is in this volume, now kindly straight away come to 153. Page 149 is 13th August 2009. Within a span of 6 months in February 2010, a complete change in stand. Now stand is what I had told to your lordship. 153. Well, the typed copy is at 153. This is to bring to your notice that in terms of the latest decision of the competent authority of KOPT, the element of service tax is not payable separately in terms of the price bid submitted by the lowest bidder in respect of the existing contract with you, or handling container of berth number 4 and 5. And my lordship notes the expression latest decision. And my lord, a new chief mechanical engineer comes.
In the middle of the game, how can you change the rules?
Well, that is the point. That is what the learned arbitrator negated and awarded the money. Unfortunately, in section 34, the learned judge refers there is a contract of 2nd April, completely ignores that provision where, my lord, the correspondence has been expressly made part of the contract, refers to the pre-agreement correspondence and construes the contract saying that there is no agreement to pay service tax on the basis of that letter. And also ignores the work order, the post-agreement conduct, everything ignored. Only on the construction of the initial 2 or 3 letters. I come to that one. That is why, my lord, this is, my lord, the crux of the matter. So, my lord, this is where they take a complete change in stand. So, my lord, we kindly, my lord, come back to the list of dates. I'll just complete. I showed your lordship, my lord, serial number 18. That is, my lord, the relevant ones have been made in bold in the list of dates. The respondent intimated to the appellant that in terms of the latest decision of competent authority, no service tax is payable. Then January to March, the respondent refused to pay the withheld amount of bills amounting to 6 crores and odd for the months of January to month for recovering service tax till date paid. So whatever service tax they had reimbursed, initially they recover only the difference of 8 to 10, and then whatever they are reimbursed earlier, entire thing recovered from my bills. So 6 crores and odd, and earlier recovered 2 crores and odd, 8 crores and odd. Then, my lord, they don't pay from January 2010 onwards, my lord, any service tax on the bills. Then on 14th May 2010, my lord, the learned arbitrator was appointed, an honorable retired judge of our High Court. This is the order of appointment, which is at page 101. I need not trouble your lordship. And my lord, the respondent authorities were directed to keep by way of fixed deposit, my lord, 40% of the amount recovered from the appellant's bill on account of service tax separately. And my lord, 2010 arbitration is concluded, my lord, 18th April 2011. Award is passed. My lord, kindly straight away now come to the award. Volume 4, page 267 to 304. পুরোটা পড়ো।
কেন 267?
এই অ্যাওয়ার্ডটা দাও না, মিনিট ফিনিট লাগবে না।
267
হ্যাঁ ঠিক আছে। আরে তোমার স্ক্যানে না কিচ্ছু ওঠেনি, স্ক্যানে এত পাতলা উঠেছে। Page 267, Lordships have it. Pursuant to an order dated 14th May passed by Honorable Justice Shunji Banerjee in AP so-and-so and AP so-and-so, an appointment of the present arbitrator was made on a request under Section 11 of the Arbitration and Conciliation Act for the reference of dispute to arbitration. That page 268. Lord, I am skipping, my lord, the filing of the statement of claim. Kindly straight away come to Lord, both parties had agreed that, my lord, this matter can be done, my lord. Kindly see, my lord, page 269, internal page 3 of the award. In spite of opportunity being given, neither of the parties has adduced any oral evidence. The list of documents was filed and both the parties have made inspection of the documents and completed other formalities. Elaborate submissions were made on behalf of the claimant to highlight the items of claim and to obtain reliefs. Equally, the respondent has filed their counter statement and or counterclaim as specifically stated in the pleadings. The learned senior counsel of both sides had made detailed submissions on different dates of sittings as suggested and agreed by the parties. After conclusion of submissions, both sides have filed their written notes of argument. So essentially, my lord, since this was really an issue germinating from the documents, there was no scope of much of oral evidence. So oral evidence was adduced by neither of the parties. Parties proceeded on the documents. Now, my lord, kindly straight away, I am skipping, my lord, the other observations for the time being. Kindly straight away come to page 277. Lord, I'll come back to this, my lord, when the quantification part I make my submission. Because there is an issue raised, because a supplementary affidavit was filed by my client, my lord, quantifying the amount. They raise a dispute before that, my lord, before the learned judge. But since the learned judge, my lord, lock, stock, barrel held that there was no contract, that was not gone into. But that will be significant. I'll make my submissions on that also. 277 kindly come to, my lord, as of now. But this is, my lord, what was initially claimed in the statement of claim. That is, my lord, 2 crores and odd, which is, my lord, in excess of 8%, whatever was adjusted. And then, my lord, 7 crores and odd, what was adjusted over there. But, my lord, this was slightly modified. I'll come to that later. But my lord, in respect of the figures, lordship can take it from me that to the extent of 8 crores and odd, there cannot be any dispute because a chart was handed over by Mr. Jena to the arbitrator and my lord, in course of proceedings, my lord, as to what is the amounts that were deducted. So, my lord, if my lord, I am able to successfully, my lord, canvass that there is an existing contract and the learned arbitrator, I'll establish that, my lord, whatever award has been passed, 99% is, my lord, also corroborated from, my lord, the document of the respondent itself. So, my lord, this is what was claimed. Now, my lord, straight away, let kindly come to the issue as to whether there was an agreement or not. Let I just read from page 278. My lord, last two paragraphs. The pre-bid meetings were held on August 5, 2003 and terms and conditions agreed upon at the pre-bid meeting were deemed to have been frozen in accordance with the terms and conditions of the said contract and the same could not be varied or modified. Now, this is important because this is the main pillar of their contention. My learned friend's contention before the Honorable First Court was that since it was frozen, it could not have been modified. Ignoring, my lord, the letter of 6th of October. So, my lord, this is what was also contended before the learned arbitrator. In connection, clause 2.7 and 3.12 have been set out. Lordship will find that clause, my lord, at page 279. Roadwings International was the lowest bidder, attended the said pre-bid meeting. At the said minutes of the pre-bid meeting, it was recorded as follows. It has been decided that all statutory taxes, duties, levies, etc. invoked will be included in the rate to be quoted by the prospective bidders. No taxes, duties, levies will be payable extra on the rate quoted. This is the letter which was initially written in the pre-bid meeting much prior to the letter of 6th of October. This is referred to. The bidders present had gone through the recorded minutes and accepted the same. The aforesaid frozen tender condition, including the condition with all statutory duties, taxes and levies, service tax would be included in the rates and will be payable by the successful bidders were duly communicated to the bidders, including the petitioner by the letter dated 17 September. Roadwings International Private Limited, in short RIPL, and all parties including the RIPL knew well that all existing taxes, duties and levies within the existing or to be imposed was to be included in the rates to be quoted and it was payable by the successful bidder and they acted accordingly and the said fact would be evident from the letter dated addressed by RIPL dated 6th October having reference so and so. By the letter of 6th October, RIPL intimated the respondent as follows. Well, this is the other 6th of October letter by which I am accepting and saying. On that date itself, another 6th of October letter is coming and crossing saying that no, it will be payable extra. And that becomes the document. And so, my lord, some modified there, some kept it there, whatever it is, my lord, the court thing was done. But this is very important, what has been quoted. We accepted your terms and conditions as mentioned in the above NIT and are enclosing your tender document, part 1, duly signed in all pages towards acceptance of your terms and conditions, including the clarifications, decisions contained in your letter dated so and so. At page 280, 17 September in triplicate. We are enclosing here with part 2, constituting the price bid duly signed by us unconditionally. The certificate in this respect is also furnished along with this as desired. Certified copy of the money receipt for a sum of 20,000 towards ones. The word NIT stands for notice inviting tender. The letter dated 6th October issued by the respondent was referred to in paragraph 4 of the statement of claim was issued through inadvertence and was not taken into account by the said Road Wings International Private Limited. The price bid was opened on January 14th and RIPL submitted its price bid including contents of the alleged letter. By the letter of intent dated 28 January, respondent accepted the price offer of the said road.
Sorry, Mr. Chaudhary. So when you submitted your offer, that included the service tax because you were going by the earlier letter.
Yes.
You did not modify your bid.
Yes, because after the clarification came, I kept my bid as it is. But we had the option, either I wanted to or I did not want to. We had the option. Because well, this is not an issue at all because it was clarified that well, and we were paid. Well, most importantly, we were paid. They also understood it is extra. But I came to know before opening of the bid. Which was well in January. I came to know that. I chose it's a commercial call. I said that even if it is there, I have given a bid. I don't want to change it. I am giving it. Treat it as that.
You're entitled to.
Yes.
You're entitled to.
Then 282nd last paragraph. On 28 January, the letter of intent was placed on RIPL being the lowest bidder. In the said letter of intent, even then I was the lowest bidder. In a copy of the minutes of 5th August was made part thereof. The alleged letter was not made part of the letter of intent. Alleged letter is being made because before the arbitrator, my lord, they disputed the 6th October letter, saying not that it is not genuine, saying that it was issued by inadvertence. Well, I'll come to the statement of defense pleading. It is not that the 6th of October letter is not a genuine document. But the stand of the Kolkata Port Trust was 6th of October letter was issued by inadvertence.
For 3 years, they acted upon it.
Yes. And well, the learned arbitrator has given 3 reasons. You again reiterate in the work order, you act upon it, and 6th October letter, assuming it was issued by one errant officer by inadvertence, for information, copies was given from top to bottom of the hierarchy of all concerned with the tender. How can you say by inadvertence it has been done? This was, my lord, the finding of the learned arbitrator. And all these are completely ignored by the learned judge, my lord. And then, my lord, on 2 documents, pre-bid, my lord, entire award set aside. When the law is, my lord, in 34, that once it is held that the arbitrator has the jurisdiction and has come to a finding, the court, even if it comes to a different, will not interfere.
Why don't we release your friends?
Yes, sir.
All other matter released for the day.
We're at page 280. This is important. The second last para, the agreement dated 2nd April 2004 was signed by the then chief mechanical engineer in charge of the respondent. The terms and conditions of the agreement between the claimant and the respondent were such that the quoted rate was inclusive of service tax. All other allegations in the statement of claim have been denied. Milord, these narrations are, Milord, this is a paraphrasing of what their case was. All other allegations in the statement of claim have been denied and disputed in seriatim. However, with reference to paragraph to the statement of claim, I give the paragraph to the respondents contended that the said additional services as claimed by the respondent is extra and beyond contract. Service tax was paid by the respondent under mistake of fact. The particulars are given as below. This is very important. This is the particulars which the respondent gives as particulars of mistake of fact. The claimant and the said officer were under a common mistake of fact that the claimant is not entitled to claim and the respondent is not liable to pay service tax towards and terms of such contract which were not shown. Parties to the said contract was under a common mistake that service tax was payable extra by the respondent, even if the quoted rates were inclusive of service tax. The respondent and the said officer were under the mistaken belief that the claimant and the respondent was liable to pay service tax extra, even if quoted rates were inclusive of service tax, while answering the said clause 11 of the major terms and conditions governing the contract. The said officer and the claimant proceeded on the mistaken belief that the contract contained the terms and conditions providing for payment of service tax extra. The work order dated 18th May could not alter the conditions of the agreement dated 2nd April 2004. Well, pausing here for a moment. Even 2nd April 2004 agreement refers that 6th October is made consciously part of that agreement. And work order, I shall show, they are issued by different officers. In any event, the respondent states RIPL having accepted the agreed rates payable to the claimant, which was inclusive of statutory taxes, duties, and levies, and having accepted letter of intent acted thereupon, the claimant as successor of RIPL accepted that service tax will not be payable extra to the agreed rates. This is, my lord, their contention. Now, my lord, I straight away come to the finding. My lord, figures I am not troubling your lordship. May I kindly come to page 283. After the figures, item 1 to 7, what my claim was, then comes the finding. The documents referred by both the parties had been admitted in evidence by waiving formal proof. But the question of probative value of such documentary evidence remained open. Both the sides also preferred not to adduce any oral evidence as mentioned earlier. Mr. Shorkar, learned senior counsel, assisted by so-and-so, appeared for the claimant and made elaborate argument. Mr. Shorkar submitted that in connection with the tender, certain pre-bid meetings were held, including one held on 5th August, when the question of payment of service tax by KOPT arose, and where it was officially stated that by KOPT that no taxes, duties, or levies shall be paid extra by KOPT over and above the rates quoted. The claimant, however, wrote a letter of 20th September 2003, which was replied by KOPT by a letter of 22nd and 23rd September, issued the letter of clarifying that, at page 284, clarifying the condition of the tender and the contract. The said letter was issued by the then Chief Mechanical Engineer. Thereafter, KOPT issued a letter dated 6th October 2003 in furtherance to the letter of 22nd, 23rd, which again was in continuation of the letter of 17th September, where KOPT Container Terminal Manager clarified that service tax at the rate of 8% shall be paid extra on the amount payable as per the rate quoted in the tender. In fact, against this manager, in their statement of defense, they tried to make out a case that they had initiated disciplinary proceedings, as if this person had entered into some sort of an unholy transaction with my clients. But all these have been negated, I'll show that. Because the learned arbitrator has observed 6th October letter, it was informed right from top to bottom. Work order was issued by a completely separate and independent person, and you have acted upon and paid by it, and it was known to all. So it can't be either a mistake or any suspicious act of any individual. And more importantly, it has been expressly included in the agreement of 2nd April. There is no allegation that 2nd April agreement was fraudulent or entered by mistake of fact. Now, at page 284, last paragraph. Mr. Shorkar has made much emphasis to point out that office copy of the said letter of 6th October was produced by KOPT. Kindly see who produces the copy, office copy. was produced by KOPT on a notice to produce. Because when no formal evidence was laid, documents otherwise admitted, probative value on formal notice to produce, the office copy is produced by KOPT. So no question of the document not being genuine. It would be evident that the letter was issued upon a telephonic conversation dated 3rd October by the chairman, and copies of letters were circulated to all concerned officer of KOPT, including the then chief mechanical engineer, and contents therein had not been disputed by KOPT. It is also argued that subsequently a letter of intent of 28 January was issued informing the said Road Wings, page 285, Road Wings International. This letter is accepted along with all clarification and confirmation. On 2nd April, the contract was signed between KOPT and the claimant, and the letter dated 6th October has been mentioned as a document by which the contract has been added, amended, varied, and or modified by way of mutual consent, and the said letter was to form and read and construed as a part of the contract. It is further argued that the letter dated 22nd, 23rd was mentioned in clause 2C, indicating that all letters in furtherance of the letter dated 17 September were treated to be part of the contract. The contract was made in terms of the pro forma prescribed by KOPT in its tender document. The said pro forma also stipulates all correspondence between the parties that amend the contract, and those shall be read as a part of the contract. It is argued on behalf of the claimant on 18th May, a letter was issued by KOPT in favor of the claimant in respect of the contract as annexure, forming an integral part of the said order, being a copy of the major terms and conditions. Well, this is the work order terms and conditions, what I showed to your lordship. That I am at page 6 lines from the bottom. Consequently, the claimant has been raising bills and the invoices with separate service tax component, and the same has been paid by KOPT. It is also submitted that the respondent has also relied upon a document dated 23rd June, where the officer on special duty had written to the FA and CAO that the chairman had held that 8% service tax is payable on the contract of the contractor under the agreement, and the excess service tax paid above 8% should be adjusted. In a letter dated issued by KOPT of 31st July, it has been held by KOPT that service tax will be payable, but the rate of payment has been disputed. According to Mr. Sarkar, the contract between the parties clearly indicates that service tax is payable. The letter issued by KOPT on 18th already stipulates service tax shall be payable extra. The contract between the parties, as per Mr. Sarkar, is sacrosanct. There cannot be any reliance on any negotiation previous to the formulation of the contract. Then reliance is placed on the judgment of Pren versus Simmons, where it has been held that negotiations previous to formation of the contract are inadmissible to prove the intention of the parties. There is no ambiguity between the contract between the parties. It should be in the contract between the parties. The parties have acted on the agreement, admitted the obligation to pay service tax in letters issued by KOPT to the claimant. Mr. Sarkar has referred to the decisions. I am not trying to, but kindly see what was the contention of the respondent. 286, last paragraph. Mr. Bachawat, senior counsel, duly assisted by Mr. Jana, argued on behalf of the respondent. During the arbitration, sitting senior officer of the Board of Trustees of the Kolkata Port Trust attended. Amongst such senior officers, Mr. Shopun Basumelat, some officers, the senior officers have been named. As per submission of Mr. Bachawat by a tender notice of so-and-so, this is again, my lord, reference to the earlier terms and conditions. My lord, the main contention of Mr. Bachawat, my lord, lordship will find. Yes, 287, my lord, last paragraph. Being the lowest tenderer, KOPT issued letter of intent to Road Wings. Thereafter, the contract dated 2nd April was signed by the parties. Learned senior counsel submits that to adjudicate the dispute, the entire correspondence between the parties should be considered in proper perspective. Prior to the execution of the contract, a pre-bid meeting was held on 5th August between KOPT and principal bidders, including RIPL. Discussion on the points raised by the bidders were recorded at the minutes of the meeting. A representative of one of the bidders suggested that all statutory taxes, duties invoked should be payable extra to the service provider and price bid should be submitted accordingly. Thereupon, it was decided that all statutory taxes, duties shall be included in the rates to be quoted. Next para. It would be important to note that the exact question and issue was raised, clarified, and decided that all statutory taxes, levies invoked to be included in the rates to be quoted, and no taxes, duties, and levies will be paid extra on the rates quoted. This is an essential term of the contract. Well, this is what is their submission, Mr. Bachawat's submission. By the letter of 20th September, Lordship will notice entire submission is based on pre-6th October letter, or my lord, more importantly, my lord, ignoring the terms of the 2nd April contract. And my lord, instead, they are placing reliance on my 6th October letter, by which, my lord, I had said that yes, I agree to that was in terms of the earlier one. But kindly look at it conversely. If I would have, my lord, altered my position, whatever it is over there, would it in any way change the terms of the contract? How I have written my letter? That wouldn't have. Either there is a terms of the contract saying it is payable extra, or it is not there. Whether I change my bid or not, or I keep my bid unchanged and the letter records that it is in terms of the earlier decision, that would not alter it. And assuming, my lord, it would have been, then, my lord, the 2nd April letter would have, my lord, not expressly mentioned the 6th October letter. And this is exactly what, my lord, I straight away now come to the finding of the learned arbitrator. But straight away, my lord, I skip their submission. And only one submission I want to show to your lordship. My junior rightly points it out. Page 289. Second line. This is the submission, my lord, which by a letter of 6th October, the alleged letter of KOPT with reference to its letter dated 22nd September informed the principal bidders, including RIPL, the service tax at 8% shall be payable extra on the amount payable extra on the amount payable as per rate quoted. KOPT requested the proposed bidder to work out their competitive offer, keeping this in due consideration. Mr. Bachawat draws the attention of the arbitrator. Now, this is very important. Kindly see what is the submission. That this letter is merely an information to the proposed bidders to work out their respective bids. If these are to be considered as an offer which was not accepted by any proposed bidder or ignored or rejected by each of them. In fact, RIPL submitted its bid on 6th October, ignoring the alleged letter of 6th October. It had crossed. Both are on 6th October. It had crossed. When they asked us to modify our bid, I could have lowered my bid. I chose not to. That is all that has happened. But after the contract is made, they can't say that in your offer you had referred to the earlier letter, therefore you are now bound by that. And that is all happening after 4 years. But the individual, the personnel changed. There was some other issues for which, my lord, this complete volte-face was done. Now, my lord, the finding of the tribunal. That kindly straight away come to page 293. But I am coming, prior to that, my lord, it's the submissions of Mr. Bachawat, which has been paraphrased by the learned arbitrator. 293, last paragraph. The arbitrator has heard the submission of the learned counsel of both sides very patiently on several dates as suggested and agreed and as per convenience of the learned counsel. The arbitrator has also considered all pleadings, various letters, correspondence, minutes of the meeting diligently in greater dimension. The arbitrator has tried to understand the view of both sides with open mind, independently, impartially, and impassionately. On submission of the parties, the following question arises for adjudication. Is service tax payable extra over the bid price as per the terms of the agreement between the parties? If so, at what rate such taxes is payable? Is service tax at all payable by KOPT extra over bid price? Is service tax payable at 8% or at the prevailing rate from time to time? Is the claimant entitled to relief? Well, rest of it. And there are two issues with regard to the counterclaim also. Upon perusal of all the letters referred by the claimant as well as referred by the respondent, it is clear without any doubt that during the pre-bid meetings, KOPT clarified and decided that no extra service tax or any statutory duties and levies are payable by KOPT. But before the final agreement of 2nd April was arrived at, a most important letter had been issued by KOPT on 6th October 23. This letter is very, very important and it is to be considered in the proper perspective. It is to be adjudicated as to whether there is any impact upon the concluded contract between the parties. By way of ready reference and for proper appreciation, the said letter is quoted here in below. The letter is quoted. I have placed that letter. I am not troubling your lordship. Page 296, internal page 30 of the award. During the arbitration sitting, the claimant had asked the respondent to produce the office copy of the aforesaid letter, and consequently, the respondent had produced the original office letter from their custody, and as suggested and agreed by both parties, a Xerox copy of the office copy of the aforesaid letter was given to the claimant and also submitted. For appreciation, the exact office copy is quoted here and below. So, the arbitrator, to dispel any doubts, first quotes from the letter relied upon by us, then quotes from the letter which is the office copy, so that there cannot be any manipulations or interpolations, let us say. These are the quoted portions. 298, kindly count. On perusal of the said letter, it is found that the said letter was addressed to all the 7 bidders, including the claimant. This letter was issued by the container terminal manager by forwarding copies to all important officials, namely Secretary, FA and CAO, Traffic Manager, Chief Mechanical Engineer, Chief Engineer, Additional, Deputy Chief Engineer, Deputy Container Terminal Manager, EACOM, PS to the Chairman, PS to the Deputy Chairman. It has also been recorded for information, please. And this is important. This letter is being issued pursuant to the Chairman's discussion with the officer on special duty just prior to Puja holidays, and that the contents have been communicated by the OSD to the undersigned over telephone on 3rd October 2003. So, my lord, 6th October letter was actually being written by that container terminal manager pursuant to communication on behalf of the chairman of the Port Trust, that you say that it is that. The question of allegation arises as to whether this offer made by Kolkata Port Trust by inadvertence or mistake of an individual, or it is a collective decision taken by higher authorities as conscientious steps before concluding a contract by a formal agreement of 2nd of April, as referred to in pages so and so. At running page so and so formal deed, there is clause 2, which indicates inter alia that the following documents have been deemed to form and to be read and construed as a part of the agreement. And my lord, the arbitrator notices, my lord, that letter has been specifically referred to. Then, my lord, page 299, internal page 33. First line, my lord, clause 2C, item 5 is the letter number MEC CTN MHC dated 6th October. This is an important letter which, according to KOPT, the letter was issued unilaterally and the offer was made inadvertently or out of mistake. It has not affected the concluded contract on the decision of the pre-bid meeting. This contention is not acceptable to the arbitrator. This letter dated 6th October 2003 issued by KOPT is not a mere mistake or made inadvertently. It is an outcome of the decision collectively by the highest authority. It has great impact upon the concluded contract between the parties. In fact, before the final and formal agreement is arrived at, this specific offer letter is made by KOPT and this offer has been included in the formal agreement in clause 2C Roman 5. And my lord, arbitrator, my lord, once he comes to a finding that this is a concluded contract, my lord, the law as it stands, let us assume for a moment, my lord, the learned judge sitting in 34, section 34, exercising section 34 jurisdiction. Even if, my lord, for argument's sake, I assume that, my lord, could have come to some other conclusion, my lord, that cannot be interfered. I am trying to show that the arbitrator's conclusion is perfect. Because, my lord, when I show the impugned order, it will appear that the learned judge has not even considered the 2nd April contract. Moreover, on the basis of the formal agreement, the work order is issued, and in clause 11, it is very clearly stated that the payment will be made every month within 30 days from the date of submission of the bill, complete in all respects. Service tax at 8% will be payable extra on the amount payable. The online accounting dealing may be examined for introduction in due course with provision of suitable banking instrument. Till then, all efforts will be made to realize payment within 15 days from the date of submission of bill for a particular month. A revolving letter of credit will be opened in favor of KOPT. This starts at running page so and so, so and so. This is very important. The argument of Mr. Bachawat is that extra payment of service tax is superfluous and is contrary to the concluded contract, which has been arrived at upon consistent and serious pre-bid meetings, and the decision arrived at and accepted by the claimant and other bidders. On perusal of the office copy of the letter and also looking at the formal agreement and its averments, as well as reference of the said offer letter, and consequently the work order was issued by indicating clearly and in unequivocal terms that service tax at 8% will be payable by KOPT. This aspect has been understood by both claimant and the respondent for a good length of period. Bills were issued and payment has been made consciously by KOPT. These subsequent events are consistent with the offer letter of 6th October and the formal agreement of 2nd April and clause 11 of the work order. These consistent steps do not appear to have been made inadvertently or by way of mistake. To the greatest surprise, nobody on the behalf of the respondent has come to speak before the arbitrator that a mistake has been committed or such step has been taken inadvertently. It must be remembered that pleading is not proof. A story of mistake or inadvertence has got to be explained, and such explanation must be convincing, and the matter can be adjudicated on the basis of such evidence. KOPT is a statutory body having large number of senior officials. There is no internal step taken that anybody has been made responsible for committing such mistake, or that they have taken any steps to make somebody responsible for issuance of the letter which is otherwise contrary to and or inconsistent with the concluded contract by decision taken in the pre-bid meetings. But after this finding, my lord, at the stage of section 34, a pleading comes that we have taken disciplinary proceedings against her. Before the arbitrator, nothing comes. No evidence is adduced. And a case of mistake with all those particulars, my lord, are there. Regard having had to the materials on record, arbitrator has no hesitation or there is no doubt in the mind that the said offer letter is a genuine offer made by the collective decision of the highest official of KOPT, and the said offer letter that has been included in the formal agreement and followed by appropriate clause in the work order is practically acted upon by subsequent payment of service tax. It is clearly held by the arbitrator that between the parties the contract is there to make payment of service tax by KOPT. So there is a specific finding. Well, may I pause here for a moment, because next comes the contractual part, that whether it is 8% or that. But before I go into that, I'll come back to page 301. Kindly take the impugned order, because now that I have placed the arbitrator's finding, kindly see what is the finding of the learned judge apropos this. Lordship will get the contrast immediately. Kindly take the impugned order, which is at 481, volume 6. That I'll come back to the next portion.
We have read the award. Don't come back. We have read the award. The rate changed by operation of law. Therefore, whatever the applicable rate is.
Lordship must have noted, Mr. Bachawat fairly submitted that if the arbitrator comes to a finding that there is a contract for payment of service tax, it will be as per the prevalent rate. That was his submission also. But before, my lord, the learned judge, my lord, a complete different stand has been taken, that the council cannot make any concession or contract on behalf of it. The rate is 8%. Therefore, you have to stick to 8%. Even all these, this is the case. Now, my lord, kindly come to page 481. I am coming to internal page 3 at page 483. I first show, my lord, what was the submission, and I'll straight away come to the finding, because vis-a-vis, my lord, the contract, existence of the contract.
Why don't we see the finding from internal page 7?
Very well.
Para 10.
Very well. Upon hearing the learned counsel appearing for the petitioner and respondent, it is clear that the dispute centers around two issues: whether service tax was payable by KOPT, and if yes, whether service tax payable at 8% or at prevailing rate, whether the amount of 9 crore awarded to the claimant was justified. Both the above issues were decided in favor of claimant ABG in the arbitration proceeding. In order to test whether the impugned award can be upheld within the statutory framework, the reasons given by the learned arbitrator in support of the findings at first should be seen. ABG has relied on the letter of 6th October 2003. Well, this is on that question, issued by the container terminal manager. Then, my lord, I need not trouble your lordship with this paragraph, para 13. The findings of the arbitrator with regard to this issue are as follows. A letter of 6th October was issued by KOPT before the final agreement dated 2nd April. Now, kindly mark here, my lord, the learned judge refers to the agreement of 2nd April. But later, my lord, lordship will not find any reference at all. As if, my lord, completely, my lord, it has, my lord, evaporated. And no reference to the work order either. This letter had a bearing on the concluded contract. The original letter was produced by KOPT. Then, my lord, D, the statement of KOPT contained in this letter, namely KOPT was liable to pay service tax extra at 8%, was a collective decision. Clause 2 of the formal agreement referred to this letter and hence was deemed to be a part. Offer was made by KOPT through inadvertence is not acceptable to the arbitrator. Then, my lord, this is important. Clause 11 of the work order reinforced the liability of KOPT. This also, my lord, is a reasoning which is noticed by the learned judge, but later not referred to. The disputed letter of 6th October. Well, I pause here for a moment. Well, after what has been shown, why at all it is being called a disputed letter? I have, my lord, my first point is this. I said this before the first court also. You are admitting that I have issued it. Your case is a mistake or inadvertence. So why call it the alleged letter? Why call it the disputed letter? And, my lord, frame a cloud, my lord, around that and say that this officer only had issued it. Why? Because, my lord, the learned arbitrator asked them to produce their records and has quoted both, compared it. KOPT acted in terms of the disputed letter of 6th October by making payment. Nobody on behalf of KOPT came before the arbitrator to depose. KOPT had committed a mistake in issuing disputed letter. Lordship knows, my lord, in plaint, when we plead fraud or mistake or undue influence or coercion, we have to give particulars. Order 6, Rule 4 requirement, well, this is of course arbitration. But mere pleading would not do. If you are pleading something which is contrary to the written document, firstly, whether it can be admissible in evidence, that's a different question. But if you are pleading that, you have to give evidence to plead mistake of fact or fraud or whatever. And the arbitrator noticed nobody came there and nobody even said that it was there. Nobody turned up to give evidence. Based on the above finding, the arbitrator came to the conclusion KOPT had acted upon the letter, the formal agreement and the work order and had made payments of service tax and 8% extra on the amount payable as per the rate quoted. Now comes, my lord, the finding, and I go slightly slow. The above findings will be needed to be tested on the grounds taken by KOPT for setting aside of the award. On the factual score, there are several important considerations which the arbitrator overlooked in coming to the conclusion. The formation of the contract between KOPT and ABG culminated in the acceptance letter or letter of intent dated 28 January, in which it is clearly stated that the contract would be as per tender condition agreed between the parties. This LOI only mentions ABG's offer letter of 6th October and subsequent clarification of November 2003 together with another letter of ABG of 15 January. There is no reference to the controversial letter of 6th October having reference number MEC CMT CTM MHC. Notably, 6th October 2003 letter referred to in the LOI has a different reference number of RW1 CPT 03. Well, this is a case made out by my learned friend's client, my lord. Completely erroneous. Our letter is Roadwing's letter, trying to confuse the court. RW1 is Roadwing's letter's reference. And both letters, my lord, have been referred to, and they are also aware. Deliberate attempt, my lord, to mislead. Besides the above, the relevant clauses in the tender conditions in respect of freezing of pre-bid conditions, price bid, duration, general conditions and special terms also do not refer to any liability on the part of KOPT in respect of payment of service tax at 8% or otherwise. Clause 9 and 10 of the pre-bid meeting dated 5th August 2003 make it clear that the parties agreed that all statutory taxes in vogue will have to be included in the rates to be quoted by the prospective bidders, and more importantly, that no taxes duties will be paid extra on the rates quoted. The letter of KOPT dated 17 September states that deviation from the tender condition now stands frozen, and in the event of any deviation, the offer of ABG will not be accepted. But pausing here for a moment. After 6th October, when my offer is accepted and this is happening, why isn't being referred to? The offer letter of ABG dated 6th October records that all terms of notice inviting tender were accepted. The offer letter of ABG dated 6th October enclosing its price bid also makes no reference to payment of service tax. But kindly see, impugned award makes no reference to the letter of intent acceptance letter of 28 January 2004 by which ABG's offer was accepted by KOPT. Look, this has been discussed. In fact, the learned arbitrator has referred to, then comes the letter of 6th October. and the contract was concluded between the parties as per tender conditions. The impugned award consequently also does not refer to the fact that the concluded contract makes no reference to the controversial letter of 6th October. Well, completely erroneous. Completely erroneous. In fact, my lord, submissions have been made, my lord, to confuse the learned judge that the 6th October letter is the letter of road wings, which is not. And that is why this finding, this is what, my lord, is the understanding. And I read once again, my lord, 491, para 16. Impugned award consequently also does not refer to the fact that the concluded contract makes no reference to the letter of 6th October in which. And my lord, two things are possible. Either now, only if the 2nd April letter is contract is completely ignored, this statement can come. Or my lord, this is my lord, the learned judge in the previous paragraph comes to a finding that the concluded contract is the January letter of intent.
I read the order, Mr. Chaudhary. The only thing that weighed with the learned judge was that by issuing the letter of acceptance on 28th January 2004, the terms of the contract stood crystallized. That's the word her Lord Ladyship uses. After that, no amount of nothing can change it.
No. Now,
work order, formal contract. We are not saying that we are agreeing. We are not saying that.
No, but let us assume that's a plausible view. Let us assume that. Let us assume that. But it is nobody's case. It is nobody's case. Even not, my lord, I shall show from the statement of defense. It is nobody's case that the letter of intent is not. Letter of intent was also made part of the formal contract.
This letter of acceptance is the letter of intent.
Yes, letter of acceptance is, my lord, it's also the letter of intent.
That's 28 January.
Yes. My lord, letter of intent or letter of acceptance is only an intimation that you are, it's a, well, they have, well, pre-formatted documents. It's only an intimation. Your bid is as made on the letter of 6th October is accepted. You are bound by the tender terms and conditions as modified by subsequent amendments from time to time. That is also is being recorded. Because it is not possible in that letter to refer to all the correspondence, which is formally done when the contract agreement is executed, after I put in 85 lakhs as bank guarantee. Page 491, my lordship.
You need not place the award, the impugned order any further. We have gone through it.
So, my lord, 493, my lord, this is how, my lord, I am thrown out of the window because of this finding only that there is no contract. And my lord, on the point of law on this aspect, my lord, I just show your lordship one more paragraph. My lord, I had relied on the case of, my lord, McDermott. Paragraph 111 was relied upon. I'll just show how the learned judge has distinguished that, because on that, my lord, it is there. Let kindly come to page 502, para 31. Para 31. McDermott International versus Burn Standard has been relied upon by ABG for the proposition that the conduct of the parties would be a relevant factor in the matter of construction of a contract, and further, that construction of contract is within the jurisdiction of the arbitrator. In McDermott, the Supreme Court, relying on D.D. Sharma, opined that once it is held that the arbitrator has the jurisdiction, no further question shall be raised unless it is found that there exists any bar on the face of the award. There cannot be any dispute as to the proposition. A distinction must, however, be drawn as to what is meant by construction of contract as opposed to terms of the contract. Well, kindly notes this. A distinction must, however, be drawn as to what is meant by construction of contract as opposed to terms of contract. But construction, there is a bar. Terms of contract, the court will do it. The court will make the terms of the contract. With respect, the distinction between construction of a contract and terms of contract becomes relevant where the arbitrator fails to identify the terms of a contract from a plain and meaningful reading thereof, and instead takes into account documents and materials which do not indicate what the parties intended. If the arbitrator in the present case takes recourse to the latter, the award must fail on the ground of perversity. Section 28(3) of the Act makes it mandatory on the tribunal to take into account the terms of the contract. The law is that construction of the terms of a contract is within the exclusive domain of the arbitrator. The thrust of the 96 Act is on the intention of the parties as evident from the contract. The emphasis on the phrase terms of the contract under 28(3) is to prevent an arbitrator traveling beyond what the parties intended under the contract. The assumption is that arbitrator would construe the intention of parties in accordance with a correct understanding of the terms of the contract. In the present case, the arbitrator has disregarded the unambiguous intention of the parties to be bound by the tender conditions as stipulated in the several documents, including offer letter, letter of acceptance, and agreement of 2nd April 2004. Pausing here for a moment. If this is there, and work order, the conducts, McDermott's authority is you will take into account subsequent conduct. Everything ignored. Whenever Lordship wants, tomorrow.
It'll be in the list. Kalke keyword. Yes, because our appellate side list is not too long.
What is, I am not the Lordship's usual procedure. This is not, that are non-commercial. So non-commercial every day.
Kalke, shuno. After appellate side, non-commercial, original side, non-commercial will be taken up. Lekho.
Acha, designated.
Mr. Chaudhuri, learned senior counsel representing the appellant, opens his submission but does not conclude. This appeal is directed against a judgment and order dated December 24, 2020, whereby the respondent's application under Section 34 of the Arbitration and Conciliation Act, 1996, for setting aside an arbitral award published in favor of the present appellant, was allowed. Paragraph of Mr. Chaudhuri, opens his, does not conclude. So paragraph lists the matter once again on Kalkit date for further hearing, as the first item under the heading appeals from orders. Appeals from orders to tule dao. Shuno er upore je duto ache kalke thakbe na. Bola ache? Oh, ache bola ache. Amongst the first 5 items, because there are other
very well,
yes, first 5 items. Chalo.
Appellate side item 1, my learned junior had taken my leave. Let it retain its position when Lordship, because today Lordship had original side matters. I did not trouble your Lordship. This is regarding Section 82. Bank guarantee matter, my lord, 12A leave was granted, but my lord, interim reliefs not granted on that ground.
In terms of CPC.
We'll come to that, my lord. There are two.
Two views on that?
No. My lord, it's very short point, my lord. That is settled, my lord.
Without granting an opportunity to the government, one can pass an entry.
I will not urge that. My point is limited. Next date has been fixed on 11th of August. I am saying you fix it on the next date you sit in presence of the other side. In the meantime, bank not to disburse the money. Otherwise, my suit will become infirm.
But that is also an interim order. Anyway, come.
We'll come.
Sure.